overview of your rights as a tenant in a landlord-tenant proceeding. Ms. Chittister, can you hear me?
Yes, I can.
Ms. Conway, can you hear me? Apparently, yes. Ms. Gales and Ms. Moyer?
Yes.
Yes.
Excuse me. All right, you're all here for a landlord-tenant matter. And as such, you have a right to hire a lawyer. If you cannot afford an attorney, you can seek assistance from legal aid or other legal assistance. We don't have court-appointed counsel in civil matters. You have a right to have the matter heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance and pay the $50 jury demand fee unless the judge waives your right to paying that fee because of your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, that's a community action agency, a housing assessment and resource agency, that's Neighborhoods Inc., or a federal help for homeless veterans program if you have veterans service. You do not need a judgment against you to get assistance from the places listed above, despite what DHS tells people. The judgment is not necessary. You've got the summons and complaint, although the judgment, frankly, is helpful. You may be able to reach an agreement with the plaintiff by going through mediation. Only if both parties are interested, I can help set up mediation. So far, that's not happened even once, but maybe someday it will. You may be able to reach an agreement with the landlord that means the case would get dismissed through a conditional order of dismissal. And if that happens, we will assist with that. All right, let's take Mr. Dutka's matter first. Robert Kolsinki and Carolyn Kolsinki versus Elena Gales and Raina Moyer. This is a land contract forfeiture claim. Mr. Dutka, what's the status here?
Right now, Your Honor, there hasn't been any payments made since the date the complaint was filed. And at that time, they were $2,100 past due, going actually all the way back to May. And there hasn't been any payments received for October and November. So our calculations are they owe $3,300 in land contract principal and interest through the month of November.
And we have less than 50% of the contract price paid?
That's correct.
All right, Ms. Gales and Ms. Moyer, what's your position here?
I'd like to be able to catch it up. I don't want to leave my home. I've been there over 20 years. I just had a lot of medical and other personal problems that came up. But I do have every intention of paying them and keeping my home if possible.
Well, I think it could be. First thing we have to do is you're entitled to have one at least 7-day adjournment, whether I like it or not. So today is November 10th. We continue this to November 17th. And again, we're all filled up. Boy, every day is just fall. Mr. Dutka, are you available at 2:15 on November 17th?
Yes, sir, I am.
Now, even then, you'd get 90 days to redeem the land contract. So if it was more than 50% of the purchase price, you get 180 days. For less, you get 90 days. So you've got about 100 days try to get caught up in this before they would execute the foreclosure. Mr. Dutka, in addition to the principal and interest, are there taxes?
There probably is, Your Honor. I guess I can look those up. It wasn't a real big deal when we drafted the forfeiture notice. I'm thinking aloud here that probably there's at least the summer taxes for 2025 probably not paid, but there could be more, and I can get numbers for next week.
All right, that would be helpful. All right, now, Ms. Gales and Ms. Moyer, we don't have emergency housing funding for land contracts. Ms. Conway, you can't smoke while you're in court, so I'm going to put you in the waiting room while you finish your cigarette. So there is no emergency financial assistance. You could seek traditional financing from a bank or other lending institution and buy the contract out, but I'm sure they would like to see this rectified also. We're going to reconvene. You're welcome to come in like you did here next Monday, the 17th at 2:15 p.m. And if they get what they ask for, I'll tell you how much is due under the contract, and I'll give you 90 additional days to pay that before you'd be subject to foreclosure and eviction. Do you understand?
Yes, sir.
Do you have any questions?
No, sir.
All right, we'll address this again next Monday at 2:15. Mr. Dutka?
Yes, sir.
You might have interest in our next case. Mr. Bush isn't here yet. It involves Judy and Michael Hartman and the estate of Natalia Winnicky.
Oh my gosh.
I remember you had a case almost 40 years ago involving some of those participants.
If I ever got around to writing a book, I would include that as a chapter.
Okay. All right. Anyway, you're good to go. I'll see you next week.
Thank you, sir.
And ladies, I'll put you back. You're free to go.
Thank you, Your Honor.
Thank you.
I'll put them in the waiting room now. I've got Ms. Chittister here on behalf of Ms. Hartman. I've got Ms. Conway here. Her matter isn't set till 1:35. I don't have John Bush. There he is now. Mr. Dutka wrote a book. I'd buy it. John Bush wrote a book. I'd buy that too.
Thank you, Judge. I'll be sure to put the acknowledgement to you in the front.
Okay. All right. Welcome, Mr. Bush. All right. Let's take up Hartman's versus the estate of Natalia Winnicky. The file number is 252067. Holly Chittister is here. Holly, were you Natalia's granddaughter?
Daughter.
Daughter. All right, this is also a land contract forfeiture case, similar to the last one. Again, it's alleged that less than 50% of the purchase price has been paid. Mr. Bush, what's the current status here?
It's my understanding that the property is still owned by the estate. In other words, I have not seen an assignment or a deed transferring the property from the Winnicky estate. information provided my office is they're $6,750 behind on their monthly payments. And that would be through November 1st of 2025.
November 1st or November 30th?
That would be through November 1st, I believe.
So they would still owe November?
No, that's figuring the November payment now.
All right, through November 30th. Ms. Chittister, what's your position?
So my niece, the land contract was available to be reassigned, which my mom did to my niece who was residing with her at the time of her passing. Last year, Nicole was diagnosed with cancer and was unable to work.
All right, what is Nicole's last name?
Nicole Slocum, Slocum.
All right, and so who is she to you?
She is my niece.
Okay.
So she is Natalia's granddaughter.
All right.
She's not in any of the documentations, Your Honor.
So, as I was saying, the land contract allowed for her to transfer the contract. My niece got sick. I reached out to I reached out to Mr. Bush and to the Hartmans, as well as the social worker, as she was eligible for some assistance to help with the payment to prevent this from happening. And we did not get a response. So unfortunately,
Well, generally, they won't give you assistance on a land contract, but your grandmother, rest her soul, was never one to do things by the book. And when you assign a land contract, you don't just hand it to somebody and say, here, it's yours. The plaintiff is entitled to be clued in on it. But right now, the actual party at interest is the estate of Natalia Winnicky. Are you the personal representative of the estate?
I am.
Assigned by the court?
Yes.
All right, so you
That's
have.
correct, Your Honor. There is an estate open and she is the personal rep, at least there was.
Okay, so Holly is
Yeah.
the personal rep. All right, very good. Is anybody in the house?
Yes. My niece is still
Who lives
residing
there?
My niece, Nicole Slocum, and her 2 children. And she wants to get this paid up. We had requested the information because the hospital had funds to help with that payment while she was in treatment and during her recovery, and we could not get a response. So that is still, I spoke with the social worker and they said that that's still a possibility. My
That would be
niece has
great,
also
because the
filed.
whole purchase price was not that significant. It was $30,000. And
Correct.
nothing's been paid in a year. And the payoff is probably less than $25,000.
Actually, it's
So they were-
$26,830 right now.
I'm sorry, what
Is
was
the
that?
payout.
$26,083 as of today.
Okay.
26,830 is payoff total.
26,083.00. $26,083.
Can I ask you one more time, what was the amount that's past due right now? You said
The
6,000.
past due
what?
amount through November to bring the contract current is $6,750. Again, excuse me.
Thank you. Okay, thank you.
Now, the law says we have to adjust. I'm going to continue this to next Monday, November 17th at 2:20. Does that work for you, Mr. Bush?
I'm going to walk into another room real briefly to get my calendar.
All right.
Your Honor, can I
Now,
say
even
something?
then, yes, just a moment. Wait till your lawyer gets back.
Okay.
Then you would get 90 days from that date to redeem the land contract. So there's about 100 days here. And just because your mom said she assigned it to Nicole, that in and of itself doesn't answer it, but it's between Natalia Winnicky and the Hartmans. So if you can pay it all off, I guess it doesn't matter who it is. But right now, the contract is between you as the personal representative of Natalia's estate. Yes, Mr. Bush, does that work for you?
I have the calendar. What time were you talking on the 17th?
Next Monday, the 17th at 2:20.
Oh, I can do that by Zoom, yes.
All right. Ms. Hartman, you wanted to say something?
Yes. I've asked for Mrs. Chittister's phone number, and I've never been given it. And I would like them to pay me completely off. What's happening now is illegal because they're giving me payments from this person, and that's like I'm renting it to them, and I'm not. And I won't enter into a contract with those people. So if she wants to do the contract, that is fine, but she needs to be responsible for these payments.
All right, well, that goes without saying.
The land contract that you had that was drafted with between the Hartmans and my mom, there's a section in it that says that the purchaser may assign or convey his interest in this contract or any part thereof without the written consent of the seller. My mom
All right,
did
well, let's
sign
read that.
something.
That's paragraph 8. The purchaser
Yeah.
may assign or convey his interest in the contract or any part thereof without the written consent of the seller. Any such assignment or conveyance shall not result in the probability of waste or other impairment of the seller's security. Any violation by the purchaser of this condition shall be considered a default of one of the conditions in the contract. Under no circumstances shall the assignment or conveyance release purchaser from his obligation under the provisions. So if your mother said, well, here, I'm going to assign this to you, Nicole, that doesn't release her from her obligations. And that is paragraph 8. So we'll try to sort that out further. Again, the total payoff would be $26,083. All right, we'll address this further. We're going to be just as busy next Monday as we are today. All right. I'll see everybody. Ms. Chittister, I don't want you to come just by telephone. If you can't connect by Zoom, I'd like you to come in here to the courthouse.
Okay, I will connect. I was just having problems connecting on that Zoom, the meeting itself, but I can do that by Zoom.
Yes.
I will figure it out. I just didn't want to be late today, so I did the telephone call because I was not able to get online with my computer. So I can go ahead and do that if that will work.
All right, yeah, that would be helpful. All right, I'll see you next week, next Monday at 2:20.
Thank you, Judy.
All right,
Thank
thanks.
Give me a call, okay?
Thank you.
Judy, please call me later today.
I will. Thank you, JP.
Both departments. John, I have a guess that you didn't draft that land contract.
That's accurate, Your Honor.
All right, next up is Michael Wolf Sr. versus his estate versus Michael Wolf Jr. Someone is here as Michael Wolf. Is that Mike Wolf Jr.?
That may be both the complainant and the tenant. They may be together, Your Honor.
All right. Mike Wolf, could you unmute your microphone? All right, who am I speaking with?
Is the microphone unblocked, Your Honor?
Are you Mike Wolf Jr.?
Yes, I am. Mom, are you okay?
All right, Mr. Wolf, I didn't advise you of your rights yet. And I'm going to skip ahead for just a moment. We'll do Churchill and Conway, and then we'll come back to this one. Ms. Conway, could you unmute your microphone? If I could do it, I would.
Please.
Elizabeth, can you hear me? Ms. Conway, could you unmute your microphone?
It's been unmuted the whole time.
All right, very good, very good. All right, this is file number 252111LT. Susan Churchill and Elizabeth Conway. This is a property on 7th Street in Three Rivers. Miss Conway is in the upstairs apartment. Ms. Churchill wants her to move. She filed a notice to quit on August 27th. Miss Conway had been in custody for some of that time, but is out now. And are you in your apartment right now, Miss Conway?
What'd you say?
Are you in your apartment right now?
No, I'm not. I actually wasn't in custody any time when they filed a complaint because I never received a complaint in August. I filed police reports multiple times on that resident. So anyways, a long story short, I never received a notice. She said she wanted me to move because I was blaming her roommate doing criminal things, but she even did something kind of illegal too. But I'm not going there with that right now. It's just about landlord tenant. All I'm saying is I never said I wanted to stay there and stay in their house for free or whatever, do whatever I want to, when I want to, or anything, or do anything weird, because I'm not weird like that.
All right, do you wish to move?
I filed multiple complaints to the police department, and it's not just basically on one circumstance from those people. It was multiple other people too. But I don't appreciate you going on and saying I'm writing a book or something like that, because I caught you at my legal address when my mom was dying, and my mom lived in a nursing home. And I remember talking to you on the phone specifically, and I told you
when you were here in court.
I told you though, on the phone on your clerk's office, you said you wanted to see John Dupree in court, and now he supposedly doesn't have anything on record because you're kind of a little nervous because I caught you at my legal address. I changed my address from Constantine so I can get my ID, and I ended up staying there briefly in this lady's house. But like, I'm sitting here listening to you, and then I hear you saying to my mother when you pulled her out of a hospital and pulled her outside in front of the yard where my legal address, and Dupree was not outside doing anything. It was you guys, Lisa, that used to work for the jail.
Conway, could you just take a breath for a minute?
I can't, because
you suffer from mental. None of the things you just said happened. But let me ask you a question. Are you willing to move out of this property?
What I'm telling you is you're going to be arrested, Middleton, and I'm sorry, but I caught you touching my mother, and she's a Bingaman.
Yes, so those are.
I caught you putting your hands on my mom. You told my mother you were going to be the reason. No, do not call me delusional, because I have it in my home fucking photographic even memory. You pulled my mother out in the middle of her dying bed when she was already getting home invaded at the nursing home, and you knew that because you broke into the police department with your family a couple months before that.
All right, Elizabeth, I'm going to mute your microphone. Miss Conway was at the Forensic Center for a considerable period of time pending a competency recertification. It took a while. So we got over that hump, and my fear is she has regressed. If it was a criminal case, I don't think she'd be competent to proceed. Let's see if I can bring her down here, but I've never met her mother, seen her mother, touched her mother. So, Miss Churchill, is she still there?
She hasn't been there, but I was told that she was in jail for a while. And she showed up 2 days ago at my house, took some stuff and left. So she hasn't actually stayed in the apartment for a while, but she was never paying rent. She was never supposed to be a tenant.
She told me that's where she was going to go when I let her out of jail. So let's bring her back.
Complaint against Middleton for touching
All right,
my mother.
Elizabeth, do you wish to stay here at this property?
Do I want to stay at the property? Do you think I want to
Yes.
stay at that property after 3 hours PD threw me 100 miles an hour to Kalamazoo for more than one person, but to do a rape kit with her fucking tenant? After he tried to murder me because he was afraid I was going to report rape
Which
kit.
case are these?
Do you understand the words that are coming out of my mouth right now? And then you have this woman fucking hostage me with guns, and that guy's up there tampering every pack of cigarettes I have that I paid $10 back for, trying to hostage me there because he was touching me when I first moved in there. I don't want to fucking hear it.
Elizabeth, you're not doing well at all.
I'm not doing this with you because you broke the law, Middleton. You brought my mother out in her dying bed a month ago, and you were in the middle of the road in the middle of the night saying, I'm not losing my job because of you, Teresa Winrick. Basically, you didn't say her name, but she was dying. And Dale Carlisle was out there too. And you're not going to just blame it all on these two people anyways, because you guys were touching my fucking
Elizabeth,
mother.
you are in an acute
Middleton.
psychotic
Middleton,
episode.
I am not.
I'm going to continue this to 2:30 on November 17th.
I will defer to your discretion,
You
Judge.
sent me away for 8 months, you retard. You sent me away for 8 months saying I needed a psych eval and I needed to learn what the law meant. So it took me 5 months to learn stuff about the law because whenever I've been in trouble, I'll plead guilty if I can get out. Because one time you put me in jail for missing a video court on disloyal person when I was a victim and stuff like that. And then you wanted to cut my
Elizabeth,
bond for
we're going to
$25,000.
continue this matter to next Monday at 2:30.
You already apologized.
And
me
you're
once
going to
for
get
calling me a
10
drug addict.
days from that date to move out or you'll be evicted.
Okay,
I don't have the
I'm filing
authority
a
to
police
order
report
a
against
competency
Middleton.
evaluation in
I
a
can pass
landlord
a lie
tenant
detector
case.
test, and I'll pass a lie detector test
Judge,
any
do I
time of
need
day.
to leave,
Middleton,
let her in the
you're not
home?
putting your hand.
Ms. Churchill, what was your question?
Do I need to let her back in the house?
Yes, she is a tenant at sufferance. You can't lock her out. She lived there for some time. I'm not even sure how she got in there. She had a number of retail fraud cases, and then the most recent cases were all driving matters. She continued to drive with a suspended license. I let her out after 27 days in jail sometime last week, and she told me she was going to go back to this apartment, Susan's place in Three Rivers. But yes,
Well, she was
is a
never a
tenant.
tenant. She was a
So let me see.
squatter.
She's on a roll here. Let me see if I can bring her down a little bit.
I was like, you know,
Elizabeth, do you understand you need to come back next Tuesday?
You
Tuesday
hear
at
what I'm saying,
2:30?
Middleton? I'm trying to save your job for a minute, but you were hurting my suffering mother because she was getting home invaded at the nursing home because you.
All right, I'm going to delete you. I'll see you next Tuesday at 2:30 right
Don't
here,
you
but you
Lord,
can't
you're
say
going to
stuff
jail
like
now.
this on the
I want
record.
you arrested, Middleton. You're going to jail.
Yes, all right, thank you. You probably and several others. Those are difficult cases. I've been dealing with her for several years and I've watched her decline. And, but she's there. She doesn't have a lease. She's not paying any rent. The plaintiff wants her out, is entitled to get her out. We'll try again next week. We'll see whether she shows up. But I don't have a better answer for her right now. All right, Mr. Bush, I'm going to take a minute. Ms. Churchill, I wish I had a better answer for you too. Somehow you let her in there and now she has tenant status and I can't just summarily kick her out. So we have next week and then she would get 10 days from that day. If I could get her to take a breath and have a rational thought, maybe I could get her to just agree to move out, but I don't think that's going to happen. So
Do I have to
try
put up
again
with her
next
for
week.
another week?
What?
So I have to let her in for another week?
Yes. My fear is she's going to end up getting arrested again because of her mental illness. But if that happens, we'll deal with it. All right. I hope she stops driving. All right. Now I need to take a minute and advise the Wolves of their rights. Good afternoon, Mr. Bears.
Good afternoon.
Welcome to Landlord-Tenant Court in St. Joseph County. Kind of makes you wish you were in on it. Maybe not. All right. The title of this case is Michael Wolf Sr. versus Michael Wolf Jr. There is no lease. It's filed as a termination of tenancy. Nancy Nelson is the personal representative of Michael Wolf Sr. Mr. Wolf, you have rights as a tenant. You have the right to hire an attorney. Can you hear me?
Yes, sir.
All right. What do you have in your hand? A vape?
Yeah.
Yeah, just put that down. Let's pretend we're in a court hearing. You have the right to hire an attorney if you cannot afford one. There is an attorney from Legal Aid here on the feed. You may also seek other legal advice. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first court appearance or file the written demand within 5 days and be prepared to pay the $50 jury demand fee, unless the judge waives it for your inability to pay. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, that is not this situation. They simply want you to move. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, the court can help set that up. You may be able to reach an agreement with the landlord that means the case would get dismissed, in which case we would file what's called a conditional order of dismissal. Well, this comes up a lot where someone's in mom's house or dad's house and mom dies or dad dies and the other siblings want to sell the property.
No, I think they want to buy it, but they ain't.
All right, Mr. Bush, what's the status here?
Pretty much what you just said, Your Honor. It's an estate. The personal representative is receiving pressure from other beneficiaries to move the matter along. We need to get him out so the property can be cleaned and readied for sale.
Yeah, that'd be.
Now, Chelsea Peavy is listed on here also. Is she there with you?
No, and I don't even know how that happened.
Did she ever live there?
No.
She was staying there. And she was staying there with him.
When was that?
And she refused to leave, but she had,
one day.
And what's your name?
Nancy Nelson. I'm my former wife.
Your Honor, he did not have access to transportation or a computer, so she made arrangements for him to be present with her for this hearing.
Very good. Mr. Wolf, the law requires that I adjourn this matter for 7 days. And then you would get 10 days from that date to move out. 7 days from today is the 20th.
Fine.
You'll be gone by then?
Yep.
I'm going to continue this to November 14, 2025, November 20.
I believe the 17th is what you're.
Yeah, the 17th. That's the day we're using. 7 days from today is the 17th. That's next Monday at 2:45. Mr. Wolf, you think you can be out by then?
Yeah.
All right. Well, if you are out, you notify Nancy. You don't even need to be here. If you're not out, then we need to have a further hearing next week, and I would give you 10 days to move out from that.
Sure.
You know where you're going to go?
Yeah,
All right.
we get a job.
Well, if you moved out before next week, you don't even need to come for the hearing.
Okay.
All right. You have any questions?
No.
All right. Either I will or won't see you next week at 2:45. If you're gone, we won't have a hearing. If you're still in there, we'll discuss it further at that time.
Thank you, Nancy.
All right. Thank you. All right, now this is the point where we shift gears every week from landlord tenant to general civil. We have two such matters. We have Omni Credit Union versus Craig Monday. Stacy Salisbury's here on that matter. We'll set that aside for a moment. And we have Capital One versus Thad Decker. That is file number 242397.
Good afternoon, Your Honor. Jeffrey Beers, P41693, on behalf of Plaintiff Capital One.
We had this scheduled for June 23rd, and nobody showed up for either side. And so I said, perhaps the case is resolved. Then in October, plaintiff called and asked for a summary disposition date. The claim here is for $2,535.22. I had not actually dismissed it for the failure to appear or proceed. And it was dormant, I think, until plaintiff filed this motion for summary disposition. The defendant, Thad Decker, is not here.
Matter is resolved, Your Honor. Since that time, the defendant has paid in full, and we're just waiting for funds to clear. And after 10 business days, we will be filing a dismissal with prejudice.
All right. All right, I'll tickle this 14 days to await order of dismissal. All right, thank you. And thank you for showing up to tell me what happened.
Thank you, Your Honor.
You got to see some of our other kind of day it's been today.
You have a tough job.
Yes, some days it's tougher than others. Thank you. I had a guy a couple months ago fire me. He said, "You're fired." And I said, "I wish I was fired."
Wow.
But I'm not. I'm still here. All right, Thank you. I'll see you next time.
Take care. Bye-bye.
All right, Ms. Salisbury, good afternoon.
Good afternoon, Your Honor.
We're not doing too well here either. This is file 201569GC. It's entitled Omni Credit Union versus Craig Monday. This was set for discovery hearing, and he did not appear for that hearing on September 15th. It was set for an order to show cause, and we're here today. He was served with that order to show cause, and he's not here. And this is the point at which we issue a bench warrant for the arrest of Mr. Manley. Then we've also got Mr. Binkley to deal with. The claim in this case, I get back to the original judgment. All I've got is the after fact stuff. How much is the debt, Ms. Salisbury? For the judgment?
The judgment was for $19,930.90.
Which he's promptly ignored throughout.
Yes, it looks like we got a small income tax garnishment, but otherwise, no payments have been made directly by Mr. Monday.
I find that he's contempt for failing to appear for his personally served subpoena on September 15th. I find he's further in contempt for failing to appear for the order to show cause. I'm going to issue a bench warrant. Bond is $1,000 cash only. May be applied to the debt. If he posts the bond, we'll set a hearing. If he doesn't post the bond, we'll have an immediate hearing as soon as we can make it available to you. But you're very good at this, and you know how to prepare the bench warrant.
I will get that submitted, Your Honor.
Then we have a terrible running nose here. This is also a short of the show cause. No, this is the original discovery subpoena in Omni versus James Binkley. Holly Jefferson is crossed out. So this is just as to James Binkley. He has a subpoena in order to appear for
Your Honor, just as an update on this matter, Ms. Jefferson actually reached out and Mr. Binkley and her have provided updated financials. So they've actually resolved the outstanding subpoena.
all right. So there's no further action needed here?
Not at this time.
All right, very good. Thank you. I'll wait for that bench warrant. All right, good luck to you. I'll see you next time.
Thank you.
Judge, I have some, I suppose, good news for you for this afternoon.
Yeah, we got some crunchy landlord-tenant mobile home cases yet before us. Give me some good news. I could use some.
So I am about to file with the clerks. I was going to copy you on it, a stipulated motion or stipulated order in Village Manor versus Edel. That payment was received and they have agreed to quash the writ, withdraw the judgment and dismiss the case. So I'll forward that to you in just a minute. And if you're okay with it, I will tell Attorney Butchert he need not appear.
Yeah, that's fine.
Okay. And then the defendant will file a notice of withdrawal of her motion in the Golden Ponds versus Shasta Coons case. The defendant has vacated the premises. Although I'd prefer to not have a writ continue in her name. I haven't heard from opposing counsel, but they've relinquished the premises.
Well, that's good news. Now let's take a look at our timing here. Golden
Actually,
Ponds is set for 2:10.
Attorney
I have a
Cronin
very-
is calling me right now, so I'd like to take
All right.
that. Sorry, Judge.
Go ahead, I'll put you in the waiting room. Well, I'll just leave her there. I wrote need interpreter for landlord, but I'm not sure they could read my writing.
Judge Attorney Cromendike is on his way.
Very good.
Contrary to my last representation, we might work that other case a little bit, but I don't think it will clog your docket still. It's not different than what I represented per se.
All right, well, let's bring. Someone's here by telephone. Who am I speaking with?
Linda Kirby.
All right. All right, it is 2:10. Here's Ms. Sanchez. Our 2:10 matter is Golden Pond Estates versus Francis Campos and Roger Gibson. Attorney Steve Cromendike is here on behalf of the plaintiff. We were here last time and we had other counsel. Mr. Sickle was here. We made a record that rent was $990 plus court costs, plus some other things. We had a struggle to figure out what all the numbers were. But we continued the matter to today. They indicated they plan to pay it off. They're not here. Mr. Cromendike, what's the circumstance here?
I do not show that they've paid it off. The balance has gone up. We've got another month of rent due for November.
All right, what's the
And,
current arrearage?
current rent, utility and late fees is $1,582.88.
All right, we got to struggle with that again.
Yeah, that
Tell me how much is rent, how much is late fees, and how much is utilities? When we wasted a lot of time last
Did we?
week. Your associate, the poor guy, was in here, and I kept asking these hard questions that
you didn't have the answer.
he didn't have the answers to. So how much is rent?
I've got $1,385.62 in rent.
All right, how much is utilities?
$87.26, and I take that back. $80.06 is a utility charge, and then it looks like that also includes a credit card fee that's outstanding of $7.20. Don't know how you want to categorize that.
All right, and then what is the late fees?
Then I'm showing late fees of $110, and it's not totally clear to me why, but September it looks like they were only charged a $10 late fee. October and November have $50 late fees, but September is 10 on my sheet. That's how they came up with 110, and frankly, I think it's beneficial to the tenant. So,
All right, what does that add up to?
$1,582.88. According to
There does not appear to be anyone here on behalf of
double check
those defendants.
Yeah, and then additionally, court costs wise, we have a total of $323.40 in court costs, and so that's how we got
We established that last week.
Total balance of the $1,906.28.
All right, it is 4 minutes past the appointed time. They aren't here. So often they show up late. You're going to be here with me for a bit. But let's go ahead and do a default for Ms. Villa. Has anything been paid on this? In the last, now here's somebody by phone.
Your Honor, I believe there was a payment made of 1,000 from, let me see. They got some help from the Crossroads Missionary Church. They got $1,000 from them and $125 from Mr. Roger Gibson.
So
himself.
Is that in the equation, or is that money we should add into it?
It should be included already, Your Honor.
All right. Now I've got several people who are coming in here. I've got Motorola Moto. Who is that?
Hello, Judge. It's Mr. Gibson.
All right, Mr. Gibson, you're late to your own part. Let me give you a name.
And it does appear, Your Honor, that those payments were included. Those payments I'm showing were from October 2 and October 4, and those were.
All right. Now I've also got someone's telephone number, 9021. Who am I speaking with?
This is Santana Longoria, Judge.
I stole the Kleenexes from the plaintiff table. They cry less than the ones at the defendant table, so we'll get some others for them. All right, so Mr. Gibson, we were talking about your case. You weren't here yet, but you're here now. Miss Campos had a stroke, correct?
Yes, sir.
So she's not here?
No, sir.
What we determined before you logged in was that rent is $1,385.62 through November. Utilities are $80.06. There's some sort of a bad check fee of $7.20. Late fees are $10 for September, $50 for October, and $50 for November. So that leaves a total amount of $1,582.88 plus $323.40 in costs. So the total amount due, according to your landlord, to bring the property current is $1,906.28 to pay your rent through November. What's your response to that?
We Community Action has reached out. They're going to be helping us again, and with up to $1,000. And when I get this job, hopefully tomorrow, my first few checks are going to go towards it. And I also have a buddy that I've been talking to about loaning me the money to help me come current with the balance and get it paid, but he wouldn't be able to help me until the 24th when he got his tribal money.
All right, well, let me tell you what the deal is. Today's November 10th. You have 10 days from today to pay that money, or you're subject to being evicted. The only thing that will cure it is paying the entire amount. So if they give you $1,000 and you still owe $900, that doesn't cure it. But the good news is they don't have to evict you on November 20th. They have up to 56 days from today to ask for the rent and 56 days to serve it. This is another one of those where it's an eviction of the lot. Nobody is doing just cause terminations. They're all doing these screwy lot terminations. If it was a just cause termination, they would have 90 days. You would have 10 days to move out, and they would have 90 days to move or sell the mobile home. What they've asked for is me to evict your mobile home off your lot within 10 days. So it's in their advantage and yours to work something out to keep your tenancy. But if you pay $1,000 in good faith, that would show good faith. Of course, on December 1st, another month's rent is going to be due. Mr. Cromendike, would you send me I have a judgment. The numbers don't match.
I will send you one with numbers that do match.
I got 1,495. Yeah, they don't match. It would be helpful if you gave me one that did. And I won't have to scratch it all up. All right.
And Your Honor, could I ask what the bad check thing was? I believe
something to do with the utilities. There was a $7.20 charge.
Yeah, and I don't know that it was a bad check charge. I think that it was a credit card transaction fee.
Oh, okay. Credit card fee.
Okay. Okay.
All right. All right. As soon as you get this judgment, you take it to Community Action and any other agencies and stay in contact with your manager, Ms. Villa. All right. Thank you. Now, theoretically, next up is Yesenia Sanchez versus Linda Kirby. Ms. Sanchez, can you unmute your microphone?
Yes.
All right. She is here. Her husband, Santana, is also here, and Linda Kirby is here. The Sanchezes are representing themselves, but not very well. Santana was speaking on behalf of the plaintiff last week, but he's not on the complaint. She asked me to hire an interpreter to be here today, so I have done that. So I'm not sure I'm going to continue to do this on a plaintiff's civil case, but Vivian Montero, a certified court interpreter, is here with us. So we're going to start out by swearing in Ms. Montero. Ms. Montero, do you swear or affirm to the best of your ability you will translate these matters from Spanish into English and English into Spanish?
I do.
All right. Thank you. Would you state your name for the record?
Vivian Montero, court interpreter 18369.
Ms. Kirby, can you hear me?
I can.
I thought I asked you to come in live if you only were able to come in by telephone.
This is the only way I have of doing it, sir.
Now, it takes 3 times as long to do everything through an interpreter, but Ms. Sanchez asked me to bring one. So, Vivian, would you translate that?
Yes. Se tarda 3 veces más tiempo para realizar la audiencia a través de un intérprete, pero la señora Sánchez pidió un intérprete.
Mr. Gibson, you're good to go. I'm going to release you from this. You're free to watch if you wish to, but
Thank you, Judge. Have a good, lovely rest of your day.
thank you. There's a legal definition of this, which is called a big giant mess. Translate that.
La traducción legal para esto, que es un desmadre.
Made even more of a mess by the fact that we have to do everything through an interpreter.
Es más complicado aún porque tenemos que realizar todo a través de un intérprete.
This was filed as a termination of tenancy action.
Esto fue un acto presentado para una terminación
Ms.
de
Sanchez,
inquilinos.
Ms. Sanchez wants Ms. Kirby to move.
La señora Sánchez quiere que la señorita Kirby se vaya de allí.
And she served a notice to quit on her.
Y le ha mandado una notificación de desalojo
Quite some time ago.
hace tiempo.
September 17th.
El 17 de septiembre.
She also claims that there are multiple other people living in the apartment,
También alega que hay múltiples otras personas viviendo en el apartamento,
including dogs, cats, rabbits, and other
Inclusive
things that are outside the
perros.
lease.
perros, gatos, conejos y otras cosas no incluido en el contrato de arrendamiento.
They also allege smoking in the apartment.
Alegan también que han estado fumando en el apartamento.
Miss Kirby, what's your position?
Señorita Kirby, ¿cuál es su postura?
I don't have any problem moving. I have the means to move. I have just not found a place to go to yet. I am working with Neighborhoods Incorporated and through DHS or DHS, however you say that, social services, and I've got the means and the money waiting. I just haven't found a place to go.
Yo tengo el dinero para poder cambiar de casa, pero no he encontrado otra casa. Estoy trabajando con el Neighborhoods Incorporated y DHHS Tengo el dinero para poder trasladarme, pero no he encontrado un sitio.
Are
I
the
am
other
disabled.
families still also living there?
¿Las otras familias también están viviendo allí?
Keisha's and Roger and their 3 kids are here. The man named Herman and the man named Cody. The other 2 and their 3 kids that I took filed the papers on for assault, they moved out.
Hay Kish y Roger y sus 3 hijos que están viviendo aquí. Hay otro hombre y uno que se llama Cody. Un caso en contra de los 2 y sus 3 hijos que han ido.
Are the dogs and cats and rabbits still there?
Los perros, gatos y conejos siguen ahí, que sí.
Are they still there?
Siguen ahí, que sí. Yes.
It's going to be very hard for you to move as it is.
Va a ser muy difícil para cambiar de casa para usted.
Yeah, as far as being ready to move, I'm packed. I'm ready to go. Like I said, I haven't found anywhere, and I can't. I'm on disability, and I'm having to find a place that accepts my income. And I can't.
But this will include everybody else. Everybody else has to be out.
Yo tengo todo empacado. Permítame. Yo tengo todo empacado y estoy listo para cambiar de casa, pero no tengo el otro sitio donde irme porque estoy discapacitada y necesito que ellos tengan que aceptar mi discapacidad, los ingresos por discapacidad. Sí, pero todos los demás personas, todos tienen que salir de ahí también.
I haven't missed any rent payment. I'm not behind or anything.
This is only
la renta ni nada.
Miss Sanchez.
Señora Sánchez.
Sí.
You really could use a lawyer to help you with these cases.
Realmente necesita un abogado para ayudarle con estos casos.
You are still learning the process.
Usted está aprendiendo el proceso.
And it's complicated.
Es complicado.
Your Honor, I have also been trying to get representation through legal aid, and I tried several times every day last week to get a hold of the lady's name was Meg that you gave me, and I haven't been able to reach her.
También, su señoría, todos los días la semana pasada traté de comunicarme con Meg por asesoramiento legal y ella no contesta.
Meg is here with us now.
Meg se encuentra aquí hoy día.
Ms. Sanchez, the only person you moved to evict is Linda Robinson Kirby.
Señora Sánchez, la única persona que está pidiendo que se vaya es Linda Robinson Kirby.
Así es.
You didn't list everybody else or all other occupants.
That's right. Pero usted no puso en la demanda todo y ella y todos los demás y todos los demás personas que se encuentran allí.
Miss Kirby? Miss Kirby?
Yes.
That's
Yes.
one reason why I don't like to do this by telephone only.
Señora Kirby, no me gusta hacer esto por teléfono solamente.
You keep interrupting.
Usted sigue interrumpiendo.
You're talking over me and you're talking over the interpreter.
Está hablando por encima de mí y por encima de la intérprete.
Ms. Sanchez, the only one you're asking to evict is Linda Robinson Kirby.
Señora Sánchez, la única persona que está pidiendo desalojarse es Linda Robinson Kirby.
Así es, juez.
That's right, Your Honor.
Everybody else get to stay but her?
¿Todo lo demás entonces puede quedarse a excepción de ella?
Sí, así es.
That's right.
Your Honor, whenever I have your permission.
Yes.
Pues, señoría, cuando
State your
me da
name. I don't like you
autorización-
being here by telephone only also.
Señor, diga su nombre para que conste en actas. No me gusta que está por teléfono y no está en persona también.
My name is Santana Longoria.
Mi nombre es Santana Longoria.
And you're
So
one of the
this, Your
owners
Honor,
of this property?
¿Y usted es uno de los
Yes, with my
dueños
wife.
de esta propiedad? Sí, yo con mi esposa.
Go ahead.
May I continue? Yeah.
Adelante.
Yes.
Yes. Okay. So, Your Honor, this happened whenever we filed. We got notice from Roger Robinson that Miss Linda was smoking in the home, and that they did not like that because there
All
were
right,
kids in
stop.
there.
Stop. Yesenia asked me to have a translator here.
Pare ahí. Yesenia pidió que tuviera un intérprete aquí,
Which I'm paying for
lo cual estoy pagando
Yes.
yo,
because
Yes,
she
Your Honor.
claims she doesn't understand.
porque alegan que no entiende lo que está pasando.
So you have to talk in short sentences so the interpreter can translate it.
Usted tiene que
yes, I
hablar
understand.
pausadamente para que la intérprete pueda interpretar todo. Sí, entiendo.
Okay. So, Roger Robinson called me, stating that Miss Linda was smoking inside the home.
El señor Roger Robinson me llamó a mí alegando que la señorita Linda estaba fumando en la casa.
He claimed that they have told her to stop several times and she did not obey.
Alegan que le dijeron a ella que tiene que dejar de fumar ahí varias veces y no hizo caso.
Then at that time, I told Roger Robinson for him to try to evict her, which they said that they couldn't, that we had to.
No, en ese momento le dije a Roger Robinson que trata de desalojarla. Él dijo que él no puede, que nosotros tenemos que hacerlo.
That is correct.
Mr. Roger
correcto.
Robinson called me on a video call because I told him to tell Miss Linda to give me a call so we can talk about the issue. She never did.
Yo hablé con el señor Roger Robinson en un videollamada, y él en esa videollamada yo le dije, dile a ella que me llame, a la señorita Linda que me llame, y nunca lo hizo.
So it's okay if they have 6 dogs and cats and a rabbit in violation of the lease.
Entonces está bien que tienen perros, gatos, y conejos quebrantando el contrato de arrendamiento.
And there are other guests that are in the property for a long time in violation of the lease.
Y otras personas invitados a quedarse allí por mucho tiempo, nuevamente quebrantando los términos del contrato de arrendamiento.
So one tenant is asking me to evict their roommate because they smoke.
Entonces un inquilino está pidiendo que desalojo la otra inquilina porque fuma.
But everybody else gets to stay even though they're in violation of the lease.
Pero todos los demás pueden quedarse aunque están quebrantando el contrato de arrendamiento.
And I'm taking hours of my time to accomplish this because Roger wants to kick Linda out of your apartment.
Y estoy tomando horas de mi tiempo para resolver esto porque Roger quiere botar a Linda del apartamento.
So you allow some violations of the lease that apparently don't bother you.
Entonces, aparentemente deja algunos quebrantamientos del contrato de arrendamiento que no les molesta.
Your Honor,
you can, yes.
If I may, we were unaware about the dog and the cat situation, which I've already talked to Mr. Robinson about. We did not know that when we filed for the eviction for Miss Linda. We also did talk.
Stop. Short sentences.
Sí, señoría, nosotros no sabíamos de los perros y los gatos cuando presentamos presentamos el caso de desalojo para la señorita Linda.
Yes, so we did talk to them about it. We got a game plan going for the animals, and they sent me pictures.
Ya hablamos con ellos y tenemos un plan en cuanto a los animales. Nos enviaron fotos.
About the basement where Miss Linda stated that somebody was staying, which we don't find a way for somebody to be there.
Nos mandaron fotos donde la señorita dijo, pero no encontramos la forma que una persona puede quedarse ahí.
They did, however, say that they did allow 3 other people to stay there.
Ellos dijeron quedarse 3 otras personas.
For a couple of days because they were going through some issues in their home.
Por unos días, porque aquellas personas estaban pasando problemas en su casa.
So that is really all I have to say.
Es todo lo que tengo que decir.
All right, you're asking me to evict Linda for violation of the lease for smoking. Is that correct, Ms. Sanchez?
Usted está pidiendo que yo desalojo a la señorita Linda por el quebrantamiento de los términos del contrato de arrendamiento por fumar. ¿Es correcto, señora Sánchez?
Sí, esta es una de las razones por la que la estamos desalojando, porque las otras personas le están pagando la renta y supuestamente ella no está pagando nada.
Yes, that's one of the reasons why I'm asking her to be evicted, because the other people are paying the rent and she's not paying anything.
How do you prove that she's smoking in there?
¿Cómo pueden comprobar que está fumando allí?
Your Honor.
Sí, señoría.
Yes.
Sí.
I quit smoking going on 5 months ago now.
That's what you said.
This month.
Yo dejé de fumar hace 5 meses.
I've had open heart surgery and I can't smoke anymore.
Me operaron el corazón a corazón abierto. Ya no puedo fumar.
Your Honor, if I may.
Su señoría, si puedo hablar.
I sent, we sent you via email today a couple of pictures of the home and a video of that day that we had last week, our court date. And there's a video of Miss Linda smoking, so I don't see how she's claiming that she doesn't when she does.
Su señoría, le mandamos a usted por correo electrónico 2 fotos y un video para la fecha de la semana pasada, donde ella está fumando. No sé cómo ella puede alegar que ya no está fumando.
I don't have that video.
No tengo el video.
You have a video of her smoking?
¿Tenía un video de ella fumando? Sí, señor.
To your email.
It's one of these things in the email?
Yes. The last one I sent you is only a video. And the first one I sent you are photos and a video.
Dice, el primero que fue enviado fue unas fotos y un video, y lo último fue un video.
To me, it looks like they're smoking outside.
Parece que estaba fumando afuera, en las escaleras.
Certainly the defendant would have the right to view this evidence.
Claro,
Yes, there's mucho problems with this. Nobody's under oath. We haven't laid a foundation.
La acusada debe poder ver todas las pruebas en su contra también. Sí, hay muchos problemas con este caso. Nadie ha prestado juramento. No hemos establecido una base fáctica.
I didn't schedule this for a lengthy testimonial trial through a translator. This case is so screwy in multiple different ways.
No había programado el tiempo suficiente para un juicio a través de un intérprete. Este caso tiene múltiples problemas.
No, I got that open. That's a picture.
Dice que logré abrirlo y eso es una imagen.
Your Honor, if I may.
Su señoría,
Yes.
si puede, me puede dar la palabra. Que sí.
Those pictures were sent because Ms. Kirby was also stating that the house was a mess and that there was no way she could walk through it.
Esas fotos se enviaron porque la señorita Kirby alega que la casa estaba en un desmadre. No había forma que ella podía caminar a través de la casa.
Those pictures were sent to me that day.
All right, stop.
Las fotos se enviaron aquel día.
Got it.
Me fue enviado aquel día.
Mr. Longoria, you're not even a party to this
Señor
because
Longoria,
you didn't file the paperwork correctly.
usted ni siquiera forma parte de esta demanda porque usted no presentó la demanda de forma correcta.
Your name is not even on the pleadings.
Su nombre no está en la demanda.
Yes, Your Honor.
So you filed the pleadings in the name of the person that doesn't speak English.
Usted presentó el caso a nombre de la persona que no habla inglés,
Although she speaks English.
aunque ella habla inglés.
And you moved to evict only one person.
Y andan buscando desalojar únicamente una persona.
And you sent me a bunch of evidence that you didn't send to the defendant. So she can see it.
Me mandaron muchas pruebas, pero no se lo enviaron a otra parte, la parte demandada, para que ella lo pueda ver.
So these other factors that she has a lease.
Ella tiene un contrato de arrendamiento.
And she signed the lease.
Ella firmó el contrato.
And it was signed February of 2024.
Se firmó en febrero de 2024.
And it doesn't have a time period on it.
Y no hay un límite de tiempo ahí.
In fact, it doesn't even say how much the rent is.
De hecho, ni siquiera dice cuánto es la renta.
Well, I think I'm missing pages of it.
Creo que faltan unas páginas del contrato.
I've got page 1, page 8, and page 9.
Tengo la página 1, 8 y 9.
And I can't find it. Oh, here it is.
No lo puedo encontrar. Aquí está.
Now, if I interpret this as a month-to-month lease,
Si yo interpreto este contrato como de mes a mes,
but yeah, I don't even have the whole lease.
ni siquiera tengo todas las páginas del contrato.
I have page 1,
Tengo la
Page-
página 1,
8, and
Página
page
8.
13.
y página 13.
If it is a month-to-month lease,
Si es
and you give
contrato
her a
de-
month's notice,
Si es el contrato de mes a mes y le está dando un mes de aviso,
she would have to move.
tendría que desalojar el lugar.
But this case is so poor,
Pero este caso es tan complejo.
I can't quite sort it out.
Que no puedo llegar a una resolución.
I don't have the whole lease.
No tengo todo el contrato de arrendamiento.
Judge,
Yes.
Sí, señoría.
if you were to enter a judgment today,
Si usted sentara una decisión hoy,
the defendant would have a basis for setting it aside
la demandada tendría motivo para suspenderlo.
because the entire contract is not attached, which is a
Porque-
basic pleading obligation.
Porque el contrato de arrendamiento entero no está junto y esto es una obligación para este caso.
And
Well, don't worry, because I'm not inclined to enter a judgment. I'm inclined to dismiss the case, make them
No se-
start over correctly.
No se preocupe, no pienso asentar una decisión, pienso desestimar el caso y que todos pueden empezar de cero.
And if I had an appearance, I would move for the defense. I would move for summary disposition on behalf of the defense for that reason.
Y si yo le representara a la parte demandada, pediría una disposición en resumen por ese motivo.
I will state for the record, Ms. Kirby did call me and leave a message on November 5th.
Voy a decir para que conste en actas, la señorita Kirby me habló el 5 de noviembre y me dejó un recado. Quiero que conste en actas.
All right, I'm going to dismiss this case.
Voy a desestimar el caso.
The defendant is entitled to notice what exactly the claim is.
La parte demandada tiene derecho a saber exactamente qué es lo que alegan.
The plaintiff failed to include the entire lease.
Si la parte demandante no incluyó el contrato de arrendamiento por su totalidad,
The basis for the eviction is
La
not
base
clear
para-
from the pleadings.
la base del desalojo no queda claro de las alegaciones.
She is a signature to the lease.
Ella ha firmado el contrato de arrendamiento.
I guess you can evict just her,
Creo que se puede desalojar solo a ella,
but it appears that everybody in the place is in violation of the lease.
pero parece que todos los que viven ahí han quebrantado los términos del contrato de arrendamiento.
And I'm spending all this time because their roommate wants to kick her out.
Y estoy pasando todo ese tiempo en este caso porque el compañero de cuarto quiere votarla a ella.
Ms. Sanchez and Ms. Longoria, you can refile this.
Señora Sánchez y señor Longoria, pueden presentar el caso de nuevo.
If you do it, Mr. Longoria, I wish you'd put your name on it so I don't have to pay for a translator each time.
Si lo hacen, señor Longoria, incluya su nombre ahí para que no tengo que pagarle al intérprete cada vez.
Understood.
And list the proper
Entendido.
reasons why you're trying to terminate the tenancy.
Y tienen que enumerar todas las razones por la cual la quieren desalojar.
Understood.
Ms. Sanchez, do you have the whole lease?
Señora Sánchez, ¿tiene el contrato de arrendamiento por su totalidad?
Sí, sí lo tengo.
Yes, I have it.
Ms. Kirby, if I were you, I would continue to try to find a place to move to.
Señorita Kirby, si yo fuera usted, seguiría buscando otro lugar para vivir.
I haven't looked at it, but the plaintiff contends that you're still smoking.
No he mirado las pruebas, pero alegan que usted sigue fumando.
You're not under oath, so it wasn't perjury, so I don't know if you are or not, but supposedly there's a video of you smoking.
No estaba bajo juramento, así que no hay penalidad de perjurio, pero supuestamente hay un video donde se encuentra usted fumando.
I don't know where they would have got a video because I haven't, so I don't know how to reply to that.
Well,
No sé cómo
they haven't given you a
responder eso.
copy of it.
Pues ellos no han proporcionado una copia del video.
All right, this case is dismissed without prejudice, meaning can be rebrought.
Esto caso ha sido desestimado sin reserva de ley, lo cual significa que se puede presentarlo de nuevo.
All right, you're all free to go.
Ya se pueden retirar.
Gracias, juez.
Thank you, Your Honor. Thank you. Have a good day.
Mr. Stickley?
Yes, Judge.
Thank you for coming. As you can see, I have a cast of dozens still in the waiting room to address landlord-tenant matters. I just spent way more time than I had on a case without a good answer to it. It's kind of the way the day has gone. So when I get around to my criminal case, I'll give you a call or email and we'll try again, all right?
Yeah, that's fine.
All right, thank you. All right. That was a lot harder than it had to be. All right. We've got several Golden Pond cases. Some are resolved and some are not. Let's take up Village Mobile Home Park versus Hotel. That is file number 251496. Meg Bauer is here. She indicated on the record the parties have reached a resolution in that case and a conditional order of dismissal will be dismissed. Is that correct, Ms. Bauer?
Close. It's a stipulated order for a straight dismissal. The writ has stipulating that the writ is quashed, judgment is set aside, and the case is dismissed. Payment was delivered and received, applied to the account. And I believe Elaine has received the stipulated order.
All right. And then with my blessing, you advised Mr. Butchkart that he didn't have to appear. So I'll wait the order of dismissal. So we have two Golden Pond cases. One is Shasta Coons. Mr. Cromendike has been waiting through that last anguishing case. This is Golden Pond Estates Mobile Home Park versus Shasta Coons and Kyle Lewis. File number is 251804. According to Ms. Bauer, this property is vacated. So I'll defer to you first, Ms. Bauer, and then we'll see where we are.
Attorney Cromendike and I were able to have a conversation, but there are a couple of pieces outstanding that he needs to confirm with his client. So if possible, we'd like to potentially have a breakout room. Although I think Attorney Cromendike would need to speak with his client first, unless you would prefer we defer or adjourn and work out the final paperwork subsequent.
Yeah, I don't.
Let's talk about the other one. Tara Lentz is here. The other Golden Pond case is just as problematic. Golden Pond Estates versus Kristen Wallace, Tara Lentz, and Everett Valancourt. Tara Lentz is here. I'm not sure who else is here. Elena is here. I think she's here for small claims. Elena, which case are you here on?
We are here for TM Asphalt versus Travis Blair. Small claims.
All right. Reading and Worrell are small claims. I've got a telephone number here. 3667. Who's on the telephone?
Brenda Garn.
Say that again, please.
Brenda Garn, Garn.
That's also a small claims matter. So no one is here. Oh, Lentz is here. Let's talk about that one. This is file 252002LT. It's entitled Golden Ponds Mobile Home Park versus Tara Lentz, Everett Valancourt, and Kristen Wallace. Ms. Lentz is there. What's the status of this one, Mr. Cromendike?
I have not, don't have an update in terms of working things out with Ms. Lentz and Mr. Valancourt. Again, my recollection is that Kristen Wallace is no longer residing on in the property. I do have in my notes here that one of the items that we had at the last hearing and that you had asked me to look into was a maintenance request regarding their main shutoff valve and a work order that had been filed in September, early September. I did look into that and talk to my client about it, and that has been inspected, and they did take a look at it, and the shutoff valve is working and not leaking. So there does not appear to be any issues with that. And I believe it had been previously. Now, whether that was properly communicated to the tenant, I don't know. But other than that, I don't have any updates.
All right. Last week, we determined the arrearage was 2909. We struggled mightily again. You've presented a judgment that shows rent at 2235, other money 501. What's due today?
Total balance wise?
Yeah, let's go through the arrearage. Okay. This is excruciating, but let's break it down. How much is rent? How much is
rent? I have a balance of $1,975.
That's what we had last time.
Yep. I believe all these numbers match. The only difference is we've got an additional late fee
is $501.86.
Yep, 501.86 for utilities, and then there's a credit card fee and a NSF fee. And then late
All right.
fees are now $250. They were $200 last time we were here, but November's late fee has now accrued.
Which is why this judgment is $50 higher than what was discussed last time.
Exactly. And just for your reference, I'm anticipating you saying the numbers on the judgment we submitted don't match what I said. I just want to clarify the rent to retain possession on the judgment.
Yes.
Is the combination of rent and late fees.
Yes. All right. Ms. Lance, what's your position?
Yes, I've had to, because of my learning disabilities and stuff, I've had to refile with the welfare office. I talked to the neighborhood. It sounds like that's a good possibility that they are willing to help. Their math not add up in any manner. Because it states that the late fee for rent is $60 if we're $50 behind. And so that none of the numbers add up. I mean, I'm not helping my case with that, but the late fee charge, but I also signed in the lease agreement, which is no longer in the lease agreement, that there would be a service fee of $1. And from the first time I made a rent payment, I was charged $160, but the day that I was late on rent, it went up to $2, and it's been $2 ever since. I want to know why I have a return check fee of $60 worth. I have never sent a check. It's always been through transaction. And I've had people help me try to pay the rent on July, and it refused my payment. She added the money I was short, and it still refused it. I've tried to call and make payment arrangement with them. They demanded a certain amount, or they would not accept a payment arrangement. And I was told then by the welfare office to wait for my eviction notice, which I have. And now I'm having trouble with getting the paperwork through, but I've resubmitted it again, and I'm waiting for an answer.
All I can see is the top of your head.
Right.
All right, there's a lot to unpack there. $1 here, $1 there, and now I can see half of your head.
I can address the late fees if that's helpful, Your Honor.
DHS is telling people they need a judgment of eviction before they can help them. Now, where's Mr. Valancourt? Is he still there?
I'm right here. Get in the.
All right, just so I know he's there. He was in here taking a snooze last week, but he's here. He's there now. All right. Here. Okay, very good. Mr. Cromendike?
Yeah, Ms. Lentz mentioned the late fees showing $60 on her ledger. That is correct. They do show it $60 on the ledger. I only charge $50 here on the actual in the filings. And so I understand that difference there. It actually is in her advantage, like she said.
So it says 60, but you only charged 50.
Correct. So if she looks at her ledger on her online portal, the balance includes late fees at $60 a month. However, the numbers that I provided to the court include late fees at an amount of $50 a month.
All right. Now, they have to accept any payment. So if you go in and offer $100, they have to accept it. What they don't have to accept is a repayment plan where you agree to pay $100 a month for the next 26 weeks to get caught up. So I'm going to give you what DHS is asking for through November. There is due $2,235, same as last month, but there's a $50 late fee for this month. $501.86 in these other costs, utilities, and processing fee. $232.20 in cost. The total amount is $2,959.06. A money judgment is entered here in the amount of $2,463.56, $232.20, $2,695.76. That's due within 10 days. 10 days from today is November the 20th.
How much is the total again?
Now, this is another case where they're moving to evict your trailer off the lot. You don't have to move out. They have to move your trailer if they choose to. So what they need to do is work some agreement with you to get this rent caught up.
I tried to say that we were going to pay $200 a month because of us being on disability.
Well, they can agree to do that, but they don't have to. If they want to remove your trailer off this lot, I guess they can. I signed my first writ of eviction, and I'm not sure what's happening with that case. But I want you to take this order to DHS and Neighborhoods, Inc. It's got a hard, fast number on it, $2,959.06. The only thing that cures this is paying the entire amount. Partial payment will not cure it. There's also a money judgment here. Stay in contact with Ms. Villa, your manager. Truth be told, they really don't want to evict your mobile home off of there. It costs thousands of dollars. I'm not sure it can even be moved, and there isn't anywhere to move it to. So you guys need to work out some sort of way to get this paid, but start off by going to the funding agencies and see if they'll give you some help. Mr. Valancourt, did you go back to work?
No, sir, I did not. I tried.
You owe me a bunch of money, but I'll forego it to let you use whatever money you have to pay your rent.
I tried to get employment with my nephew. I would use that.
All right, I didn't get all that, but anyway, that's the status. You owe $2,959.06 within 10 days. Ms. Lentz, stay in contact with Ms. Villa. There needs to be a way to work this out. Hopefully you'll get some emergency financial aid. Of course, on December 1st, another month's rent is due.
Yes, Everett and I discussed that, and because we're not getting any answers, we did plan on paying December's rent and the utility.
Very good. All right, thank you. All right, that leaves our last landlord-tenant case. We've got 3 small claims and a criminal case, Manning. We're 10 minutes behind small claims, but that's amazingly short considering how bad everything is. In Coons, all right, we need people in a breakout room. Who needs to speak to who first?
Your Honor, I don't know that a breakout room is necessary. I think I need to call my client. So I have the property manager here, Casey.
Well, I could put you and Ms. Villa in a breakout room right here.
Yeah, I need to talk to the actual owner of the park
right.
about the potential solution that Meg and I talked about on the phone. So I don't know that a breakout room is necessary. I'm wondering if we adjourn it with the intent that we will have a solution before that comes up.
All right, let's do that then. Thank you.
And then if I may go back, I just want to clarify on the other hearing that I was here on today. This is Francis Campos and Roger Gibson. You had mentioned that the numbers on the judgment were incorrect. And I think we had a case that was the same as this past one where the numbers fee on that. Yeah, the numbers. So the outstanding rent on that was the rent that we had talked about combined with the late fees. And I think the total.
Elaine, would you bring me that Campos case back? My nose just won't stop running. Big and red enough as it is. All right, I'll indicate parties are close to resolution, but have not worked it all out. Am I correct, Ms. Bauer? She's vacated?
That's my understanding. Yes, Judge.
All right, let's continue this matter for 12 years. I should be gone by then.
Actually, if it's possible, we can put it on Friday. I don't know if that gives Attorney Cromendike enough time, but I'm then going to be out of town for a while. So
I'll figure it out.
All right, well, let's take a look. Will you be back within 12 years?
That remains to be seen. Depends on how many cases they give me.
Well, they're giving me lots of them. We could go to Friday the 14th or Friday the 21st.
Which one do you?
Campos,
Campos?
Roger Campos.
Francis Campos and Roger Gibson.
Oh, Roger Gibson. Is it in this pile? All right, well, Ms. Bauer's got big plans for November like Judge Pattison does. So let's see, we got Friday. Is Friday enough time?
Yeah.
All right, we'll continue this to Friday at I've got a landlord-tenant case every 5 minutes all day Friday for 3:10.
My hope is that this won't take more than a minute or two of your docket at the most.
All right.
I hope I didn't fix it though.
All right, that's good because we're really time crunched here today. All right, Mr. Cromendike, stay with me for a minute if we can find your other file.
I have it here. Do you know the case number?
I can give you the case number.
Well, no, we had the case. I had it in my hand. I have it right here.
Okay.
So the numbers we had were last time were 137402. No, they still don't match.
So looking at the judgment that was submitted by email here this morning, so the rent to retain possession amount on the judgment is $1,495.62.
Yes.
That is the current outstanding rent, which we talked about it being $1,385.62, plus the $110 of late fees.
Oh, it's $110 of late fees.
Yeah, and again, I don't know why that September late fee was only $10, but it benefited the tenant, so we're going to leave it that way.
All right, I'll sign that one also.
And I think the bottom line and everything else should match up.
The day is still the same, November 20th. All right, very good. All right, thank you all for your patience. I think that finishes our landlord-tenant docket.
Thank you.
Thank you all.
Thank you, Judge Steve. Thank you, always.
Yeah. We'll talk to you soon.
Sounds good.
All right, we have 3 small claims matters and a criminal matter yet to attend to. I don't have the small claims case, I must go get them. So we're going to stop the live feed for a moment and stop the And Brenda Garn, would you join us, please? And John Reading and Christy Worrell. Ms. Garn? Ms. Garn, can you hear me?
Yes.
All right, I'm going to call this case. This is Brenda Garn versus Tiffany Schweitzer. It's a claim for $7,000, which is the current limit in small claims. They were never able to serve this lawsuit on Ms. Schweitzer, so we can't proceed at this time.
I heard she was in Jackson.
Say that again.
I heard that she was in Jackson, Michigan.
All right, well, I'll allow 60-day continuance for attempted service. So I'm sorry I had to wait an hour for that, but actually we're 28 minutes behind, all things considered. That isn't terrible. So no hearing today. We can't do a default unless she got served with the action. And so that matter was continued for up to 60 days to attempt to get service. So Ms. Garn, you're good to go. If you get further information about where she is in Jackson, we can attempt that.
Okay.
All right, good luck. I'm going to remove the waiting room. All right, next up is TM Asphalt and Sealing of Schoolcraft versus Travis Blair. You gentlemen here from TM Asphalt?
Yes, sir.
All right, would you state your names one at a time?
I'm Brandon Bordner, owner of TM Asphalt.
I'm Terry Moyer, sales rep on this project.
How do we spell Bordner?
Bordner.
And Wyeth? Terry, what's your last name?
Moyer, Moyer.
And you're the service rep?
Yeah, just sales.
All right, would you both please raise your right hand? You will swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief.
Yes, sir.
Mr. Blair has not appeared.
I'm right here, sir.
Oh, he's here. I thought you were with her. All right, Mr. Blair, would you come up and have a seat?
Yes, sir.
I misunderstood. I'm sorry. That's what you get for assuming things.
So, right here, Tom.
You're the defendant.
Yes, sir.
So would you please raise your right hand?
Yes, sir.
You swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
Yes, sir.
Thank you. Sorry, I didn't realize what the deal was. Ms. Brown and Mr. Reading and Ms. Worrell and both of you, you're all here on a small claims case. I apologize, keep blowing my nose, but small claims is a separate division of the 3B District Court. Claim is limited to $7,000 and you can sue for money damages only. You can't sue for a tort. And I'll explain that later if it becomes relevant. Neither party is allowed to have an attorney in small claims court. We don't strictly follow the rules of evidence or procedure. That is, I won't make you go through a bunch of foundational rigmarole to get letters and documents in, but everybody is under oath. This is important. There's no formal record being made in small claims court, and there's no appeal. Any decision made in small claims court is final. Gentlemen from TM Asphalt, you understand?
Yes, sir. Yes.
Mr. Blair?
Yes, sir.
Ms. Brown? And Mr. Reading and Ms. Worrell?
Yes.
Yes,
You
Your Honor.
agree? All right, we're going to take this one first and then we'll address yours. All right, this is a claim for $2,825.82. Let me get into the electronic file. We get a lot of these different contractors suing on non-payment of a contract. In this particular case, I got so much junk in here, I haven't had a chance to clean it out. The plaintiff claims that amount for services rendered and the amount unpaid. The total was $13,940. Defendant paid $11,114.38, and plaintiff contends $2,825.82 is due. Mr. Blair has a different view of things, and he filed an answer. Sorry, I don't have copies of these. I have to go. He says, I agree to pay something, but this is not full amount. Working on getting a code for unfixed damage. I counterclaim for $3,000 because of the damage done to my yard, harassment by Terry Mosby.
Should have been Moyer.
Moyer, for just showing up at my house, causing issues. You can't really sue for that sort of thing.
He showed up unannounced after I made a formal complaint online about their poor standard of quality, and actually admitted that they were at fault. The owner.
All right, well, you're the defendant, so
Yes, sir.
they get to go first. I'll hear your story. You're all under oath. All right, gentlemen. Mr. Bordner, why do you believe he owes you $2,825?
I will say there has been some additions that we've had on the service charge.
You're gonna have to speak up. I'm having trouble hearing you here. Maybe it's because I'm elderly, but.
There have been some adjustments to that. He has made an additional $200 payment, and we have had another service charge added on for the overdue nature of the bill. I currently show the overdue balance at $2,665.21.
All right, now, Mr. Blair, your answer is a little unclear. You said I owe some, and I'm willing to make payments, but on the other hand, then you counterclaim for $3,000.
Well, I have a issue with the driveway itself, Your Honor. I have sinkholes developing in part of in the driveway that extend over 35 feet long and about 25 feet wide. They were not there originally. They started off as a small little hole. They have since grown and almost runs an entire length side of my driveway, which I have pictures and video of. There's several cracks. One crack in general is over 25 feet long or 22 feet long. The cracks continue to grow as the weather continues to worsen. I have cracks down the side of the driveway, which are not relevant to what Brandon's going to say. It's part of the edging, but it's not. It's actually, if you look at the driveway, it's cracking. I got samples from where my driveway is cracking, which he assured me would never do, and it's cracking here. I also have both of them. I recorded both of them on my property where they both admit that they could have easily fixed this, but they decided not to. Brandon and Mr. and Terry said that it's an easy fix with heat and a hammer, and they never even bothered to bring either when they showed up in my house the second time. I have to get estimates, but right now, small ballpark, they parked their heavy equipment along the side of my driveway, and it left 2 deep trenches, which also resulted in damaging the deck of my mower, which now I need a quote on that. They used part of my driveway. They used part of my, I had seed and I had mulch, and I had some peat moss. They used that as support for the driveway. Even right in that same spot, I have a tiny sinkhole developing there. It's probably about 5 feet long. The damages overall, Your Honor, I have not been able to get an estimate. So, but I think that with everything going on, I think it's easy to say that I also filed up with a letter, different letter. I mailed them a certified letter to which Mandy signed. I mailed them a letter, and they did sign it. I left the receipt signed. It's in my car. It's at the shop getting repaired. But I did get a signed copy, which was with I signed an official document stating that they are to fix this. They have not even addressed it or even acknowledged it, but they did just admit to cashing the check because the check was sent with the letter.
Now, which check is that?
The $200 I just sent them. And I mean, overall, they promised good, high quality asphalt, 36A asphalt. Through my investigation and my online, some of my research and looking up different cases and everything going on, you can clearly see that they use subpar material and they substitute subpar material. And as I walk out my steps, you can see that the asphalt's pulling apart and it's just turning into nothing but stone. Hot asphalt mix is not supposed to look like it's a stone or reptilian skin. And most of my driveway looks like that. Where the sinkholes are, that's about 35 feet long. That entire section looks like it's done with poor material. The causes of the sinkhole is a result of poor base setting, quickly setting the asphalt layers where they were quick to do it. And then on top of it, some material. I'm not going to pay for subpar material until I have a quote. Best case scenario, that whole section has to get tore up, just get fixed, because they have to strip it all the way down to the base layer to fix it.
All right, they're not here. You're here. You've got a laptop.
They're right. Oh, sorry.
Yeah, they're there, but if I'm to look at your pictures, it's going to be hard for them to see them.
Yeah, I didn't know.
All right, well, there is a way to tie into that where we could share the pictures, but I'm not sure. Let's see what you got, what you want me to see.
Do you want to tie it in, or I can attest, if they want to attest, they were both in person, seen everything.
I will bring it up here. We'll see if we can show.
You want to do it, man? Sorry. Oh, this is, you just want that, man?
No, I want you to come up and operate it. I don't want to wait your laptop.
Sorry, man. Sorry, Your Honor. Where would you like it at, sir?
Set it right here,
Facing the screen?
Yes.
Yes, sir.
What we're going to do is I'll probably put the camera on.
Whatever you need to do, sir.
All right, what I want to see are the pictures.
Okay. So I want to, oops. This is an email, but we'll go over that later. Asphalt. Okay, so we'll get into this, right? Gotta go back. So this is my asphalt. You can see here that this is not what high grade asphalt is supposed to look like. You can see how if you want, I could pull up the original. We can zoom in if you want, Your Honor. But you can see how this is all scaling. That is poor grade asphalt. That means they're using this is them using recycled asphalt instead of high grade asphalt, which is what's in the contract with 36A. We never agreed upon that.
All right. Are you an expert in asphalt?
No, Your Honor, but if they would like to testify under oath, what they used, so they can demonstrate through quality controls or anything they've done.
All right, well, they can't see your pictures, and I don't know if I can get my camera over there.
I can move it closer, whatever you prefer.
Right now, it's not even facing the right direction. It's on, let's see here.
I have long arms, Your Honor.
Well, they can't see that, but
whatever you need to do, sir.
On this camera right here. So let's see.
I'll bring it closer.
All right, go ahead. Okay, just show me what you want to show me.
Okay, so you got the low grade quality asphalt. I go, here's the cracking. This is just a small example of the cracking. Same cracking. Down in here, this is actual video, but underneath all of this, it's so brittle, it's falling apart, which is part of that example. And what's happening is the seams on the asphalt, Your Honor, are breaking apart. And then underneath here, water can get in. It's going to basically eventually separate, and all this these sections are going to fall apart. I mean, right now we got freezing going on. So the water's going to get in underneath all of this asphalt, and it's going to pop it up. Eventually it's going to destroy within a year or two, these sections are going to be completely gone because there's no base. It's all just up like this. Water can get in. And now it's just eventually when it freezes, it's going to lift and it's going to start cracking across the driveway. Actually, if you want, I'll turn.
No, just show me the rest of the pictures.
Here's more examples how it's just brittle, falling apart, more uneven surfaces. Right here is one example of the sinkhole, Your Honor. That's just one section. That's after a recent rainfall.
Back up.
Yes, sir. Right here.
So what am I looking at?
This is just one of the. This is
a mud puddle on top of it.
No, this is a sinkhole. Oops. This is a sinkhole from them with they did this entire section wrong. You can see how the sinkhole is starting to develop because of it. And that's just one section. You can see here that entire section is nothing but a sinkhole, and it runs all the way down that. And that's the result of them not doing this correctly at all. Their whole base layer is wrong.
So looks like a big puddle. So it's a low point that's full of water.
Yeah, and it's not even. And eventually, what's happening now is all this is freezing, and it's turning into nothing but one big ice rink. Well, this is an example of poor quality because it started out, Your Honor. If I may go back. It started off almost that size, but it started off that size over here. And now it just keeps growing. And I have more, but you can clearly see how that's just a depression right there. That's an example of poor quality. And then here, if you keep, when it goes further, you see all that? That is because they did this entire job in a hasty manner with substandard material, and they did it in a fast because they're behind schedule because of the rain we had throughout July and August. They were so far behind schedule. Brandon can attest to, if he wants to admit under oath, they were working from basically sun up to sundown and on Saturdays because they get caught back up. This is more.
All right, do you have any more pictures?
Yeah, this is the latest. You can see, look how much freezing that is. They're supposed to have measurements, but you can see all of that is all frozen because of the sinkholes and depression from poor material. So you can see, this is another video of how big this depression is. This is not what a driveway is supposed to look like. It's not supposed to sink in on itself. May I move on?
Yeah.
And you can see here, again, you can see how it clearly runs all the way down and all the way over. So it's not even draining, it's just flooding. And this entire section is scaling and coming apart. Everything in here is scaling and coming apart. We don't need that. I think this might be. So yeah, more, this is more pictures and more video. I'll start moving my stuff. Underneath all this, Your Honor, is it's cracking, and eventually my camera angle is horrible. But underneath all of this, all the way down, there's more cracking, more cracking, more cracking, more cracking, more cracking. And I'll go on. I have an actual video of all of it. Something here. So right here, as you come out, Oh, this is Terry. If you want to watch the video of Terry coming out of my house, but this is.
No, I just want to see the pictures of them.
Oh, that's it. I have a video. I think I have a video on my phone, Your Honor. If you want, I can play that video showing you how long the measurement is. And I have a video of it being over at 22 feet, if you'd like to see that.
No, just.
But I will testify under oath that it is over 22 feet.
All right, thank you. You can take your.
Thank you, Your Honor. And for the record, I was unsure that this would never happen by Brandon himself when he came out to this driveway. I have more chunks that I haven't even brought.
Are they on the edges?
All over the place, Your Honor. It's not just the edges. The end of my driveway, when I was leaf blowing it, it's starting to peel up because of how poor the quality is on one side. When I was leaf blowing it, it started bringing up chunks.
All right, gentlemen, that's quite a lot to unpack. Those videos were probably very difficult for you to see, but it does appear there's substantial low points in the driveway. He showed cracking and breaking along the edges, and he claims there are chunks. What's your response?
We can go through all of this, and I have an itinerary or list of dates and times that we've talked to him. And some of these complaints we have never heard of. So to go through some of the stuff, on July 17th is when the driveway was first paved. On July 25th, we invoiced Travis for the full amount. On July 25th, he wrote.
All right, now what was the full amount?
The $13,860 was the original amount.
That was the original quote?
The original quote and the invoiced amount. Yes, sir.
All right.
He wrote a check to us on that date, July 25th, for $10,000.01. On the 28th of July, we returned Travis's phone call about paying the rest of his bill. Travis was not happy. He wanted to pay the rest by credit card and was going to pay the full amount, but he was not happy about the 4% fee. So he decided not to pay the remainder on the credit card. On July 28th, later on in the day, Terry went out to look at the property due to the complaints that he presented to us during the phone call. Terry then offered to fix the driveway because they were just the edge cracking. And truly, all that does take is a short amount of time, an asphalt porch, and a little tamp to compact it. He refused and said that he was not going to let a crippled elderly man do the repairs, which is when he had the video of Terry sitting on the scooter. On July 25th, he made a Google review with that same video. Or 28th, sorry, I apologize. July 28th, he made the Google review. On July 29th, tried to leave a voicemail twice, one at 12:57. He called back at 4:03. Travis stated that he no longer was paying the bill in full because the driveway was cracking on the edges. And he stated numerous times that he was not going to let an elderly man fix it. On August 4th, we received a check for $112.21. On August 5th, we received a check for $2.72. Both of these have nice little comments on them. On August 5th, Terry texted Travis to try and come out to fix the cracking. We did find out it was an incorrect phone number at the time. We did try and make contact and thought it was, but that was the incorrect phone number as our mistake. On August 13th, Travis came to our office to pay the $1,000 on his account by credit card to continue paying it off. Told us numerous times he was going to take us to small claims court because he had already repaired the driveway himself using crack fillers.
So did you accept that $1,000 payment?
We have accepted, yes. Yep, and that is on the invoice as showing updated and the correct balance as well.
May I add something real quick, Your Honor, if I may, when they're done, or how?
Yeah, you can wait till they're done.
Yes, sir.
Okay. August 13th is when he came to pay the $1,000 on credit card. Said that he had purchased all the stuff and already fixed his own cracks on the driveway with material that he had purchased on his own with no consultation. August 15th, Tammy called to set up an appointment to look at his driveway for repairs to his satisfaction. He stated on the phone call that he was not sure going to look at it was worth it because he had already started repairing it himself with his crack filler from Amazon. We still made an appointment for Friday, August 22nd at 10 a.m. to have myself, Terry, and my business partner, Tammy Stafford, attend.
All right, just a minute.
Yes, sir.
All right, so he said he started repairing it himself using his own crack filler on 8/15. What was next? You made an appointment to go out there?
Yes, sir. And then on August 22nd at 10 a.m. is when we set up the appointment where we went to the property, knocked on his door. He asked us what we were doing there, continued to show us where he had fixed the cracks without our consultation. And we informed him again. At that point, I no longer felt comfortable fixing the cracks. Normally, like I said, they were very easy. And I have photos of another property that the same thing happened, that we fixed it and took about 10 minutes. Client's happy as can be. You can see before and after photos showing the edge cracking. Once he puts a product on there that I don't know the product and have no knowledge of, the way to fix asphalt is to reheat it through asphalt torches. And then to use plate compactors and rollers and vibratory compactors to repair the asphalt. With him having an unknown product on there, we don't know whether that produces toxic smoke or whether it melts or any of that. And so we could not fix any of the damage that he had covered with that material at that point, and we went over that with him. As for any damage in the lawn, the original invoice and his signed copy that he says states right in there that we are not responsible for any landscaping or reinforcing the edges of the driveways. We went over that with him. He did state that there was a wet spot on the puddle. The only video of that we've gotten that we could see, because I could not see earlier when he was showing you, it was actively raining when he showed us the puddle. And according to the standards that he has printed off for us, it says that the puddle needs to be at least a half an inch dip or a half an inch in depth in order to count as a depression. And he's never provided us with a video or a measurement for depth. And on August 22nd, when we met him there, as we ended that meeting, he told us never to come back on property. And so we have followed his wishes, and we have not contacted him other than sending updated invoices, and have had no further contact or showing up on property due to his own request.
Just a minute. I'm sorry, I don't have paper copies of these. They're all electronic. So I have to go to my screen to see. I'm looking for the clause that says, what's in the contract. We propose to furnish material and labor due upon completion. All work will be completed in a workmanlike manner according to standard practices. Any alteration or deviation from the above specifications involving additional costs will be executed upon verbal or written authorization, become an extra charge over and above the cost of the estimate. All agreements contingent upon strikes, accident, delays are beyond our control. The client agrees to cover all costs arising from litigation should it become necessary. Our workers are fully covered by workman's comp. All down payments are non-refundable. New pavement is very tender for a period of months after installation. It would be very susceptible to power steering, twist, and tire indentations, especially during hot daytime hours. Caution should be taken to avoid sharp turning or turning wheels while not moving. Small objects of any weight placed on the new pavement will tend to sink into the asphalt, i.e. kickstands, ladders, and grills. Please avoid these situations. Any lawn restoration is the responsibility of the owner unless otherwise specified. Resurfacing over existing asphalt or concrete that cracks will result in reflective cracking in new surface. If gravel base is found to be insufficient, there will be additional cost to be negotiated with the owner. So he accepted the proposal on those terms. What does the clause resurfacing over existing asphalt or concrete that cracks will result in reflective cracking in the new surface? What does that mean?
So that would not apply to this situation. That's when we do overlay, typically more in parking lots where you take off the top inch or inch and a half of a parking lot and then put a new top layer on the existing base. In this situation, Mr. Blair's driveway was done from the gravel up, so that part of the clause in the statement would not pertain.
All right, you agreed to furnish and install 6 inches of 22A gravel. Was that done?
Yes, sir.
Regrade and compact the gravel base to be paved. Was that done?
Yes, sir.
Furnish and install an average thickness of 1.5 inches of commercial base coarse asphalt and 1.5 inches of commercial service coarse asphalt. So this entire project was to be 3 inches thick.
Yes, sir.
And it says asphalt 36A. What does that mean?
36A is the designation that the asphalt plants provide for the grade of asphalt that's purchased for the day. 36A is considered an industry standard asphalt for residential driveways and produced by both Michigan Paving, Reith Riley, and Lakeland, which are the 3 main asphalt producing plants in our area.
He claims that you did not use 36A, but used recycled asphalt. What's your response to that?
I have zero control. The asphalt plants produce all asphalt in the area for all asphalt companies. When we show up, we order the surface and the tonnage that we require, and the asphalt is put into our trucks and they get tested by the state to make sure that when they say it's a 36A, they're tested periodically to make sure that the scale and size, all that matches a 36A spec.
So what you purchased, who'd you purchase it from?
Reith Riley was the producer of this gentleman's driveway.
And where is that plant?
Kalamazoo, Michigan.
And what you paid for was 36A coarse asphalt?
Yes, sir.
All right. Now, the biggest thing he has, I suppose, he claims there are depressions which are causing it to have these low points which fill with water. And that would be from an inadequate base. What's your response to that?
So when paving, I mean, you are moving, low spots can be developed due to compaction and things like that. We do fix them on a regular basis. I have an infrared machine and we go behind lots of the different paving companies through different parking lots and do repairs of low spots. Industry standard does tend to hold that it has to be a water puddle that persists for longer than 24 hours at 80 degrees. And according to Mr. Blair, the tolerance that he would like to follow is 1/2 inch.
Go ahead.
So, and I do not know, we've never been provided with a measurement of depth, and because we were asked to leave the property and not come back, and the only we've been provided was when it was actively raining, that I honestly, and I could not see the videos that he provided to you. I don't know if it's a 1/2 inch in depth, nor if it persists after 24 hours.
All right, Mr. Blair.
Okay, first, can they confirm that, Mr. Moyer, can you confirm that you called me before coming out, and what day was that?
The only thing that I can confirm to you is that I called you when we were getting ready to do the grade work you explained to me that you had, to make sure that there would be no vehicles there, you explained to me that you had kicked your girlfriend out and that there wouldn't be a problem to come anytime. And yes, I did not call you prior to the paving dates, just to be based on that and just things that I had going on. But I just went by what you said, that you would be there if they needed a vehicle, you would be there, that nobody else would be any vehicles left there. So that's all I.
And can Brandon, can you please confirm that you testified that Mr. Mosby did call me before coming out?
Mr. Moyer.
Mr. Moyer, can you please testify? What's the owner's last name, sir, Your Honor? I need him to, because he stated in his testimony that Mr. Moyer did call me before coming out because of my online complaint. He did testify that.
So you've been out to your house on several occasions, very told verbally.
That's Mr. Borden. So what's the relevance of this?
It's the fact that I made an online complaint and it goes to a, just what I said about the harassment. And Your Honor, I have a blog standard, a blog point from PM Asphalt's own website. They actually recommend that you use a hot rubber crack filler edge to seal the cracks on the edge of a sidewalk, on the edge of a driveway. This is straight off their website. I don't know this whole heat thing, but they even recommend it. I even explained to the.
All right, well, you took self-help and made some repair on it without.
That's because Mr. Moyer didn't offer any solution, Your Honor. He came out in a scooter and a boot. And all he said was, we could just heat it and hit it back together. That was his only solution, Your Honor. Never once did he state that he would call the office and make arrangements. He came out.
Well, by the time they came out for the appointment later in August, you'd already done some self-help.
It's because they offered no solution, Your Honor. Because when Mr. Moyer left, he stated that the only solution was to do two things: heat it up and tap it back in, or I need to lay down more topsoil and help prevent it from cracking further. That was the only two solutions. And Mr. Moyer was in no ability of doing that because he was in a boot.
All right.
And he was also on a scooter. There's no way I was going to make him do that.
Well, you said he didn't even come with the tools to do it. And I don't think he was prepared to do it.
But he stated that, and then the second time they came out, Your Honor, they didn't even bring the tools either. They just showed up.
Well, they came out. They said to assess yes, just a moment, to assess the project. Yes, Mr. Bordner.
So Terry, as a sales rep, is not responsible all the time for fixing that stuff. He does carry around tools with him and he does repair some things. He was on a scooter and had a broken ankle this year. And as a sales representative, as you and even Mr. Blair has admitted when I asked him the same question, how often does a sales representative that you meet at, say, a car dealership repair your car? So Terry Moyer was not given the opportunity to repair it. And when we as a company tried to be responsible and set up the meeting to address all of these, before we got out there, he had already fixed his own way all of these crack fills. We did show up with the tools because they were in my truck and Terry had another set of tools in his truck that we could have done the repairs for. Mr. Blair also just said that on our website, it does state that cracks should be repaired with hot pour asphalt or hot pour rubber. He, I do not believe, used hot pour rubber to his repair. And when we asked him what he used from Amazon, he described it as a cold pour caulk that he
I did not describe it as cold pour caulk. I described it as an asphalt caulk. And it was, you said you didn't have any idea what asphalt caulk is. I can play your words if you want to hear them, your own words.
I apologize.
I recorded our conversation.
Use the wrong terms. Asphalt caulk is fine, but either way, it does say on our website, we recommend a hot pour rubber. And that is not what he used. So even doing his own repairs, he did not follow the recommendations that are put on our website.
But neither were you guys.
All right, well, stop. We're not sitting around the kitchen table. We're at a trial. And this is all about clear as mud. Some of the things that you're suing for, you can't sue for.
Yes, Your Honor.
You can't sue for anguish and pain and suffering. You also can't sue for any damage to your lawn. So
what about my driveway where they forced their way into my garage and cracked the driveway? I don't have a quote on that, but they did force their way into my driveway, into my garage, Your Honor, and park their machine in there. And I still got to get, I'm missing tools and stuff. I got to find receipts, so I get
Wait a
that.
minute, don't just start throwing spaghetti against the wall, see if it'll stick. Let's see what's in your counterclaim. I believe plaintiff owes me money because damage done to my yard. You can't sue for that.
I don't have the number. Oops, sorry, Your Honor.
Harassment by Terry Mosby for just showing up at my house, triggering my PTSD. Well, you can't sue for that either. A, I don't know if you've established it, and B, you can't sue for a tort, like infliction of emotional distress. So
I didn't know that, Your Honor.
Well, that's common. We have it in the next case also. I have it documented that they were at fault.
I have them both on the record stating, Your Honor, can Mr. Moyer please state if he was the one who sold TM Asphalt to the current owners?
Well, I don't know what.
That's relevant because, I'm sorry, Your Honor, it's relevant because if Terry sold them this, he would be qualified to know what damages are. He's not just a sales rep, he used to own the company.
All right, fair enough. But I'm looking at your counterclaim. $3,000 because they damaged my yard. The contract says that's on you. Harassment by Terry Mosby, that you can't sue for that. So that's what's in your counterclaim.
Yes, I understand, Your Honor.
All right, so then let's look at their claim. The quote was for $13,940.20.
13,860 was the original invoice.
That's correct.
Yes. Then the actual invoice submitted on 7/25 had a credit card fee and some other stuff. So 13,940 minus 11,1438. Now, what's been paid since 11/14/38?
Since 11, he has sent us a $200 check, which brought the balance that he owes, to $2,625.82. And then due to the timing of everything, we had a finance charge added on for the overdue balance of $39.39, bringing the total amount balance due according to our records to $2,665.21.
All right, and that's close to what you pled. Now, he does seem to have some legitimate issues here. I can't tell about the sinkholes. The quality of the video wasn't really good enough for me to see it, but it's breaking up along the edges. And your claim is he didn't give you a chance to fix it. And then he used a self-remedy. The project was put in on the 25th.
So we go
and by
clients that they
within 2 weeks, he was already doing stuff to it.
It said with the landscaping that they have to shore up the edge anytime an asphalt, and we go over this with the client, is left with a full 3 to
You guys never did though.
Of the asphalt. Gravity can pull away. It's why we put that landscaping has to be done, which we go over.
Which isn't also in the contract.
All right, again, only one person can talk at a time.
Sorry, Your Honor.
We also, I have video evidence. I did this a week ago to a client that we paved that had the exact same situation. I don't know how to show you photos over Zoom.
Yeah.
It shows the exact same edge cracking, and I don't know if you can at least attempt. If you can't, please let me know. I completely understand. But you can see like that edge crack.
Yes.
And then as we zoom out, you can see the same crack along the edge there that shows the back of the car. All that we do is we take an asphalt torch and a tamp, and we heat the asphalt back up to close to the 200 to 300 degree temperature that it is when we put it down. We hit it with the tamp and it smooths everything back out. And I don't know how well you can see that, but that entire edge, the crack is gone and the entire
Yes, I can see it.
loose asphalt is corrected. That repair and that 10 feet of repairs took me maybe 15 to 20 minutes. And I talked to the homeowner and explained the same thing, that with a couple bags of topsoil, he probably never needs to call me again. If it did happen again, to call me, I'd come back out and do the same thing to address the situation. And it truly, we do that, I would say, out of all the driveways we do a year, there probably is somewhere between 2 and say 10, I don't know what the average is, but somewhere in that range every year that we get these calls and we show up with a little tamp and a torch and we heat it up and we fix it. And I would say if on the worst side you do 10 a year, I don't know. I think maybe one I've got called back to a second time.
All right. Mr. Blair, anything else you wish to say?
I would like to know why Terry just showed up if the owner himself is the one going out repairing it. Why is Terry coming out if he's the one fixing them? If it's that simple, I'm not understanding that, because I have them on recording that when they did this, they knew that this would happen. And
well, what's the difference? If the service manager comes out to look at it,
when Terry left, there was no mention of anyone coming back out or future calling or contacting. I was basically under the impression I was on my own. And then the last time I made any online complaint, I got follow-up calls asking me to change my review. That's what I thought they were doing. I've never had anyone show up at my house unannounced after I make an online complaint, but here we are. That's what Terry did.
Well, maybe he came out to see what the concern was. So, but Mr. Moyer, he says
testified that he's not qualified, though, Your Honor. If the owner testified he's not qualified, why is he the one coming out?
Well, he's qualified to look at it.
That's not his testimony, though.
Well, Mr. Moyer, did you come out and look at it?
Yes, I did, sir. And at that time, there was when we put the second layer of asphalt on, we pulled the top layer over the bottom layer, and that's what had cracked, which was very minimal amount, would have taken very little to fix it. And then there was the mention of the garage door being opened and about us having Hispanics working for us and different things like that. But that was it. And then that was kind of the end right there, is that I would get it fixed. It was, wasn't going to do it that night that when I come, but I would have fixed it. And then, we had review and stuff. We just didn't feel comfortable going back out there until we all went out. We would have fixed it that day.
So you all went out there that day, which was the 25th or something. Did you have the tools and equipment with you to repair it on that day?
Yes, sir. We both carry around those tools and equipment in our trucks pretty much the entire summer because, well, I do those repairs I do all the maintenance for Michigan Paving, Lakeland, Reed Riley, and I get phone calls on a darn near daily basis to go repair things like this for them.
All right. So you said at some point he told you to leave and not come back?
Yes, sir. And we got in our cars after he had videotaped us and he said, "Don't come back. I don't want you on my property." And that's after he had already done his own self-help repairs and those things. And we have not, other than sending updated invoices with the updated totals, we haven't made any contact with Mr. Simpson.
May I add context to when they did come out, Your Honor, they did nothing but circle around and refuse to even acknowledge. I did point out the sinkholes, and they completely glossed over it and didn't even address it. From what I'm gathering, they're gonna have to rip that whole section up just to fix it if they have to. I did point out the cracking. They had no tools with them. If they did, yeah, it was in the truck. But I mean, if I was gonna go fix something, all they had to do, if it was that long, and if they were willing to, I would have helped them. I even stated that to them. But they didn't bring any tools. They did nothing but make excuses. They walked around and were nothing but condescending, rude, and disrespectful. I got agitated, went in, grabbed my phone, started recording them, and they kept lying to me. I mean, it's just at some point in time, I mean, if they were to fix it, why didn't they say, hey, you know what I'm going to do? I got stuff in my car. Let's fix it. And they didn't even do that, Your Honor. So they had the tools. Why didn't they bring it out and say, hey, show me where the cracks are. We'll get it done.
There wasn't.
They couldn't even do that. The first 5 minutes was just me arguing with them, and all they did was making excuses about it. And at one point, before the crack was even about 20 foot long. I don't know. And I said, and I was on my own. I didn't know what to do. And I'm asking them. I even followed up with a professional letter saying, hey, you guys need to fix this because I don't feel comfortable. I mean, I can read you an online review where they broke into people's houses, and that's not normal.
What was the date of your letter?
Oh, the formal date, I don't have it in front of me, Your Honor, but I did send it out, and they did receive it. I believe it was.
We haven't cleared this one.
I know they did sign it because they did get the check. So they had the letter.
All right, well.
And I did state the depressions, and they were showing all this, Your Honor. And they glossed over it. And every time I'd show them something, they would make an excuse. So I don't know what they were planning on doing when they came out there. But they just kept, I can play the whole video if you want to hear them just.
It's still.
And I even tested the asphalt, that the stuff I applied, it had no issue. It's standard asphalt sealant. It's the same stuff that they would use. Or similar. I mean, if they're worried about toxicity, which they never even said, I could have shown them. I had a tube in the garage. They never even asked. I assumed he would know what the stuff is because their company's TM Asphalt and Sealant. I assumed they would know this stuff, but they just, when I told them what I'd done, they didn't ask, hey, can you show me? Can you please? No, they didn't. They also assured me the driveway when it cracked, and here it is right here, examples that it's still cracking. I got chunks like this breaking up still, Your Honor. They assured me if I go home right now, I can pull a chunk out about that big in one spot. And what's going to happen underneath it is water is going to freeze, and if the whole thing's done by the end of this winter, that driveway is going to start having major issues. And I think that when they were behind schedule, they used subpar material. They rushed the job. I mean, they literally broke into my garage to park their machine to cool it down. I mean, I didn't even give them permission. They showed up 2 times.
All right, let's stop.
Yes, sir.
Do you think you're part of the problem? You're so angry. If I just sit there like this, you would rant for 45 minutes. I've got another lady waiting for hear her case.
Yes, sir.
You're so angry. There's nothing that they could do to make you happy.
I tried.
Then you stopped. This is my turn to talk. Then you went out there. You couldn't wait. Within 20 days of the time they put the substance down, you're out there putting around doing something without any professional advice because you were upset about it. We don't know about these sinkholes yet because we can't tell. They came out, they talked to you, they offered to make the repairs, and you kicked them off your property.
They did not offer, Your Honor.
Well, that was their testimony.
I can play a video if you want to hear them. I have a whole video if you want to hear it.
I don't have time to hear it. So then you countersue them for things you can't sue for, PTSD and lawn damage, and the contract covers lawn damage. I agree, the edges look crappy on there, but you were puttering around out there with something without their blessing within 20 days of the time that they did it. They're a professional company that's been around here for years and years, and this was an expensive job. $13,000 isn't pocket change. And of course they're busy. They're busy every summer. So I don't take it as a criticism. They work from sundown to sunset. It just shows they work hard. So you have some idea that they gave you inferior materials and they rushed your job based on just your opinion about it. And then you're so mad at them that there wasn't anything they could do that was going to make it right. Then you kicked them off your property. And there's a contract. You're suing on breach of the contract, which controls. They gave you a price. They told you how much it was going to cost. they adheres pretty darn closely to the original quote. And according to their testimony, installed it according to standard practice. I would have liked to have given you something in your counterclaim to maybe level this out, but the counterclaim doesn't contain anything that I can award damages for.
Understood, Your Honor.
The amount due is $2,655.31. Plus $86.25 is in costs. Is a total of $2,741.56. You would offer to make monthly installment payments in your answer. But that's not going to get it at $50 a month.
Whatever the court decides, Your Honor, I would just like to reiterate that the initial contact with Terry, there was no mentioning of fixing the driveway other than him doing it himself. No mentioning of any future contact from the company to fix it. I just want to reiterate that.
All right,
which is why I repaired it myself, Your Honor. Because I was under the impression that they were not going to fix it.
We're under a very short time frame.
Did Mr. Mosby would have said, or Mr. Moore would have said, I'll be back, we'll come back Monday, I would have never had an issue. They would have had a check after they fixed it. I could write a check today, but they demonstrated that they would have no problem breaking into my property, and they showed up 3 times unannounced. That's why I don't want them back on my property, Your Honor.
All right, fair enough. One claim, you claim they didn't do it. The other company claims they weren't supposed to be there by 8:15. Or 8:13, you paid him $1,000. All right, that's my ruling. You're going to pay this at least $200 per month,
yes, Your Honor.
Starting December 1st.
Do I get instruction from the court, or do I pay directly to them?
You pay directly to TM Asphalt.
Yes, sir.
You can pay it sooner if you want to just get it over with.
Well, I plan on it, Your Honor. I have more detail once I get more. I mean, I'm going to file with Laura and a whole bunch of other things about this in the future, so.
All right, that's up to you, but I would have tried to level it out, but as I said, there was nothing in the counterclaim I could award damages for. All right, if you go out to the counter, they'll give you a copy of this.
Yes, sir.
He owes you $2,741.56. Lesson learned here, I guess, has to do with customer service. In this day and age, people post opinions which can damage your reputation, whether it's deserved or not. I had a lady today who has mental illness problems that said on the record all kinds of things that I did, which I didn't. And you got an hour's worth of a trial on YouTube that people are going to have an opinion about.
I also am 100% disabled veteran, Your Honor. That's why I put that in there.
Well, thank you for your service. What service were you in?
Army, sir. Out of Fort Drum, and then I did a year on at Bob Fenty, Afghanistan, RC East, and then another year on a contract.
That's rough duty. Today is the 250th anniversary of the United States Marine Corps, which an Army guy might only tangentially appreciate. All right, you go out to the counter. The clerk will give you a copy of this.
Straight out the same door, Your Honor?
That's right over there.
Yes, sir. Thank you, Your Honor.
Thank you, sir. Thank you for your service.
What's that, sir?
Room 107.
107. Do you need anything with the bag? Good to know.
You're good to go. All right, gentlemen. Thank you. All right. Ms. Brown, would you come up and have a seat? Thank you for your patience. You got a little bit of experience in the small claims process. We'll remove TM asphalt. I'm a little confused, frankly, regarding this next case. To tell you the truth.
I hope to help resolve that.
All right, there are two cases. No, I guess just one. Donna Brown versus John Paul Reading and Christy Worrell. You're John Reading?
John Reading, but I'll take whatever.
Reading, all right. And you're Christy Worrell?
Yes, sir.
And you're Donna Brown?
Yes, Your Honor.
Will you all please raise your right hand? You all swear or affirm any testimony you're about to give will be true to the best of your knowledge and belief?
Yes.
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 All right. There are some things in here that you can't normally sue for in small claims court. As I said, a tort. You claim reimbursement, equitable indemnity, negligent misrepresentation against Christy Worrell and Mr. Reading in the alternative, and unjust enrichment. That one you may be able to sue for. $4,500. And then I've got a bunch of stuff that I frankly can't completely comprehend. The other matter, as I understand it, the parties were not married, but they share a child. So there was no divorce. Generally, in a divorce proceeding, you can't supersede the circuit court's jurisdiction by filing an action in small claims court. And people try to do it all the time. So there's so much here, I can't quite even discern it all. But Ms. Brown, why do you believe that they owe you $4,500?
Yes, Your Honor. If you give me a moment to give you the backstory, and I will try to present this the best that I can so that you get the best understanding to the situation.
All right.
So Mr. Redding and I have two children together. We have court orders in place. I have sole legal and physical custody of the children. There was a court order established for both children that he is to provide insurance on the children and provide child support.
All right. Where are those court orders from?
They are from here within Centerville.
All right, St. Joe County.
St. Joe County, yes. And they are provided within the initial filing.
Yes.
Mr. Redding has not provided consistent insurance on the children. We have one child with very sick medical condition. He has kidney disease, and which is bilateral hydronephrosis and RASA1 genetic mutation. So insurance is very critical to him. I've been at home. I was at home taking care of children, and the children were both enrolled in state insurance. This suit that I'm raising, I had out-of-pocket expenses due to what I'm going to discuss when Christy Worrell added the insurance, and I'll explain to you why it would fall under a small claims case. So what had happened is I had requested friend of the court to have John uphold his obligation for his insurance. And he did start a policy back in February of 2024. However, he terminated that policy. That policy did not impact Medicaid on the children, did not impact my son's children's special health care. There was no impact. If I have primary insurance, it does not impact the children's Medicaid, secondary Medicaid. But what had happened is Ms. Worrell, without my permission, without my consent, used my children's information, social security numbers, did not reach out to me as legal guardian of the children or discuss this matter or how it would impact state insurance before putting them on a policy. And what she did is she put the children on a policy, but she used my address as her primary address. The state of Michigan, therefore, canceled Medicaid because she does not live at the address at 25951 Lantern Circle. So what had happened is, by her doing this, all medical bills then were rejected by the insurance company, and her insurance wouldn't cover either because of a dependency discrepancy. When she first enrolled the children, there was no marriage on file in the state of Texas during her initial hire and enrollment period. I had reached out to Tepe, the insurance company, only on behalf of the children to try to see once I got the Medicaid rejection letter, that there was going to be a lapse in coverage. And our son had important medical testing and procedures that were prior authorized and that he was going to be going for. So what had happened is this directly impacted where I had to change different plans of care around for our son because it would be astronomical medical bills. And I was able to move things where he only had two smaller University of Michigan medical bills, which I'm suing for, which I presented here, and the amounts of, I think, 88 for one and 200 and something for the other. I can get the direct amounts. And additionally, my daughter happened to have an emergency situation, so I was charged over $3,000 because no insurance would cover because of this choice made. I did not agree to that, and there was no prior friend of the court authorization, which was what they're saying. Later on, they said if a marriage was in place, but she still couldn't use my address. And I have right here to show you, this is Christie World at my address in the state of Michigan. Of course, that causes dependency issues with state benefits. She does not live in Michigan, and these children are not her dependents. So what happened is I have direct financial losses due to this. Now, once her insurance.
All right, let's talk about those. How much are those?
Yes, so I have outlined within the summary. I believe it is on damages. If you go to attachment A, statement of claim, the damages I have at $4,500. This includes medical bills from University of Michigan, one for $88, one for $130, Sturgis Hospital, $3,597.07. That subtotal equals $3,815.07.
Stop, slow down. I don't think that's added up in here. Oh, there it is. Yes.
Yes. And also, he kept the United Healthcare insurance and not changed over to hers. That one would have done mileage reimbursement, so I have included that as well. I've also
just
included.
A moment. Mr. Stickley, I asked Shayna to call down there. I don't think I'm gonna get to our friend, Mr. O'Brien.
I was just checking in because I was going to chat with you about something else, Your Honor. I didn't know how deep still were. I didn't mean to.
I'm up to here. So I can, tomorrow is Veterans Day and we won't be here. I'll be on WBET at 7 a.m. if you want to listen to my radio presentation, but we'll work on it. The magistrate set his bond at $50,000 in his other case. It is not he's already pled guilty. He's just pending sentence.
Yep.
So we'll address it on Wednesday.
Okay. Enjoy your day tomorrow. Have a fun time on the radio. And I'll see you Wednesday.
All right. Thank you. Thanks for checking in. All right. I'm sorry. We had a criminal matter that we didn't get to. But go ahead.
Okay. In addition to that, the filing fees and process server fees, which I did submit through your clerk, and she did print me up a copy.
They're separate.
If those could be included as well.
Well, those can be in excess of any other claim. All right.
Additionally, there is a lot of problems between the parties and I, and her counterclaim for day off work, she would have had to take it already because we did have PPO hearings this morning.
Well, you normally can't sue for that sort of thing.
That was a counterclaim that she placed on me for time off work. So I'm just saying that she would have been in court today, no matter what, had this case not been.
All right. There's a bunch of other stuff in here, which isn't relevant. Pictures of Hummers and a bunch of
stuff.
So
what that was in regards to, Your Honor, is.
I don't even want to know. We're just going to deal with these. So it's your contention that without your consent, and I'm not sure they need it. They had his consent. He's a parent, but they changed insurance. And because of that insurance, it eliminated your additional emergency health care benefits you had in the state of Michigan, resulting in costs that would have been covered, but were not.
Yes, and he is ordered within the order to pay out-of-pocket expenses. John Redding is.
Mhm.
And as far as
Now, that's up to them. You can't ask me to enforce
correct, anything from friend of the court.
friend of the court.
However, Christy Worrell should not have insured the children. I do have sole legal custody of the children, and any medical decisions would be up to me, not father at this point in time. And as
All
far
right,
as
what's your authority for that?
I provided it on there. That is in our parenting custody order. One was in 2015.
Well,
for
let's
Kaylee.
take a look at that.
Yes,
Uh,
in 2021, I
Let me
believe.
see if I could find it. There's so much stuff in here.
If not, I can pull it up on my computer and show you, Your Honor. I may have only included the
Here it is.
support.
It's that funky, all right, it's uniform order. What clause here?
I can show you this. It is ordered that plaintiff shall have physical and legal custody and care of the minor children of the parties. If you would like to see, I can bring it up.
I think I have it here, but I'm front of the court orders are. What paragraph?
So I'm not sure if this is in the full filing or if this is its own independent order. If you'd like to show this stuff.
I can take this else.
Okay.
The defendant shall maintain health care coverage through the insurer that includes payment for hospital, dental, optical, and other healthcare expenses. And that coverage is available at a reasonable cost, including coverage available at a benefit of employment or under an individual policy, up to a maximum of $375 for the defendant. As for Kaylee reading and John reading. I'm not sure which paragraph you're speaking about, which says you have.
I have it here. It may not be included, but this, you can look within your system. This is file number 15839. And then they combine the dockets.
All right, well, what paragraph are you looking at in that document?
The first paragraph, it says Donna Brown plaintiff,
Yes,
John Redding, order for custody, parenting time, and other relief. All parties have agreed to the court otherwise being fully advised of the premises. It is ordered that plaintiff shall have the physical and legal custody and care of the minor child of parties, Kaylee Redding. And there's a second order for John Redding that is the similar verbiage where I have the physical and legal custody at this time of the children.
all right, now let's talk about this $3,800 bill for Kaylee. What is that about?
So she had a high temperature, an emergency matter, and she had to be taken in. My mom had taken her in. I was trying to avoid taking children in during the time, knowing that there was this insurance crisis that was caused. The bill came to $3,000. I told you how much it came to, over $3,000. And I do have a letter from Sturgis Hospital. It says that please be aware the insurance company, you advise this bill has delayed the processing of your claim because of a coordination of benefits issue. When I called Aetna on behalf of my children. It was due to a dependency issue. There was an ineligibility issue with her insuring the children. That caused the problem, and it caused the Medicaid to drop.
All right, so have you paid that bill?
The bill is still outstanding, $700. I'm working with Sturgis Hospital to get it resolved. I'm still out. I still owe U of M as well, all of the other bills.
How much?
This is what I'm out, this amount right here, and if you can hand it to, this is the amount that I'm out for those two. And here's for those two. That's my total that I'm out.
$38,130.
And if you could also give him this shows that she used my address in Michigan.
You haven't actually paid that $3,597, is that correct?
I have a payment plan that I'm working with Sturgis Hospital to try to situate the situation. They're trying to rebuild things, trying to do everything that they can to try to work with me. Currently, that's the amount that is going to be showing on my credit if not fully paid.
All right. So she's laid out why she believes you owe this. It's not equitable indemnity or negligent misrepresentation. It's that you changed your insurance. Now, I'm sure it was done with good intention to put the children on your insurance, but under the way it worked out, she contends it made her ineligible for the other coverage that she had, and then your insurance didn't cover it.
Your Honor, when I brought it to their attention.
Just a minute.
May I say something?
Yes.
So prior to us insuring the kids on my insurance, we called the friend of the court and had them review both of the policies that John was responsible for. And they gave us permission to put the kids on my insurance. And in Texas, they actually recognized domestic partnership, which we did file as of 1/8 of last year. And so under my insurance, actually, John is a dependent. It's actually domestic partnership is how it's phrased. And then his kids are listed as domestic partner dependent. So he's my domestic partner. And then I had to choose under the option for his children, domestic partner dependent. So that's how it's phrased in the healthcare world. And when she, so in.
All right, let me stop you for a
an
minute.
option.
Let me stop you for a minute. So I'm not familiar with Texas, but in Michigan, if you were married, you could cover his children under your insurance policy.
So it's the same thing.
All right, so in Texas, it's not called a marriage, it's called a dependent partnership.
So we filed
Informal marriage.
Yeah.
It's stamped county seal.
So
All right,
it's
what's the date of the marriage?
It's as of 1/8 of 2025.
That is incorrect. They filed it in.
I didn't ask you anything. I'll give you a chance to speak. This is their turn.
We did file it on March 27th, but on the paragraph, it actually says on or about 1/8/2025, we agreed to be married. And so in their system, it actually is dated as 1/8/2025. And so it's the same thing. So it's seen as a marriage whenever you're putting them on there. And because of the turmoil and the disputes between John and Donna, we had been advised by a friend of the court to send her kids' cards directly to the home. If I would have used her address as my permanent address, I could not work for that company. I could not be insured in the state of Texas. My kids were also insured under that policy. I was insured under that policy. Our cards came to my home. Their cards went to their home. And Donna called my work place of employment so many times that they called me and told me that it was concerning and I probably needed to consult an attorney for how concerning it was with what she was saying. And so later after that, I actually had my company reach out to the Medicaid in Michigan to make sure that they were still okay. And they said that there was no conflict of interest between my insurance and the insurance between the kids, that there was something probably that was done on Michigan's side that was not correct, but from their research and what they had entered, it was non-conflicting to the kids.
And in fact, if you look on Exhibit 8 that she
Just
submitted.
Just a moment. What's the matter?
Oh, I was just granted.
I took.
Oh, you did? Okay. Thank you. Sorry.
All right. Who did you talk to at the front of the court's office?
It is, we spoke with both Amy Wright as well as on the 5th, Liz.
Amy Rice?
Right.
Right.
WRHT.
And then Liz?
Yes, Your Honor.
Do you have a caseworker from front of the court?
I believe it's either Amanda or Liz, Your Honor. I've got email correspondence from myself in the front of the court when we sent them insurance cards that.
All right. So before you transferred the children to your, now what insurance had you had, Mr. Redding?
So prior, which one was it?
I think it was UHC maybe.
I lost my job. And so it's a court order that I carry insurance. So my wife was nice enough to help me insure the kids to make sure, obviously my son has a lot of health issues. And I feel like that a lot of the reason why maybe something might not have been covered is because she was blowing up the insurance company's phone as well as my wife's employer regarding why it shouldn't be covered, as she's outlined in her exhibit 11, when it's just messages of her not wanting to allow the children to be insured.
By myself. She did not want me to insure them, even though Texas recognizes us as being married and I can insure them under my policy. They actually started insurance under my current policy as of 10/1, and I haven't heard anything of it affecting his insurance at all. So I'm not sure what the discrepancy was on her end. I don't know if she missed turning something in on her end, and that's why they weren't covered by Medicaid. But I personally had Aetna call my benefit specialist under the Pennant Health Services, call the state of Michigan Medicaid to make sure that there was no conflict of interest between their policies and mine.
And on her exhibit 11, it even says that there's a form that she can return and complete on her exhibit 11.
I object false evidence.
Here,
Well,
if you state it here.
They're making a lot of false claims.
Slow down. These exhibits, I'm trying to find exhibit 11. There's so much extraneous stuff in here. It's hard to, I don't know what is exhibit 11. All right. So your contention is you lost your job, so you didn't have any insurance. So you got married in Texas and your wife's company is willing to insure her new spouse's children. So she put your children on her insurance to comply with the Michigan court order. Is that correct?
Yes, Your Honor.
All right. And you called the front of the court first and said, hey, we're going to do this.
Yes, Your Honor.
That is incorrect.
Well, we'll find out when we have to call that. And so that was done. And I wasn't clear exactly what you talked about when your partnership was. When was the date that children placed on insurance?
As of May 1st of 2025.
I have a letter that says from April 14th to children, that's when the cards were mailed to me, so that is incorrect, Your Honor.
Say that again.
April 14th, I received the letter, so May 1st is incorrect, Your Honor. The children were insured already in the month of April. The informal marriage that they submitted was 3/27/2025. There was no record with the state of Texas during the time that she enrolled the children, which is why the beneficiary situation started. I had called Aetna, not her employer, multiple times. That is incorrect and lies. There is also a false police report that Ms. Worrell has submitted on me in regards to that. I only called in regards to my children's insurance, where Aetna themselves are the ones that told me prior to any medical treatment. That's how I knew it wasn't going to be covered, because Aetna said, no, this is going to cause major dependency issues, because the way that this employer works, that your children can't be dependents. Excuse me, it's my time. What had happened was.
Stop.
First, I could have been misconfused on the dates, but
they were insured.
All right, so either in April or May, the children were on your insurance.
yeah, so it was either April 1st or May 1st. I mean, they were.
Well, the point is, the date of service here was May 27. Is that correct? For your daughter?
I believe the date of service, yeah, there was about a 2-month period that the children were enrolled. The insurance started April. I believe it ended in June. I got a COBRA statement that insurance had ended. That was sent June 11th. So insurance was terminated during the month of June. I did notify Mr. Redding and Ms. Worrell that, hey, this is going to impact. I also went to DHS office.
Right, stop. I ask short questions and you give me a long paragraph.
I apologize.
So the date of service for your daughter was May 27th. Is that correct?
That is what it shows on the bill. I believe that's the date.
The dates of service for your son were April 29th and May 16th. Now, they billed United Healthcare Community Plan Insurance. Whose insurance was that?
That would be the state of Michigan that rejected. They were on a United Healthcare Community Plan. And it became active once Christie's policy ended. It reactivated.
Well, it says not billable service. I'm not sure what that means.
It's because she had started a primary insurance with a dependency issue. I'm also the one who reached out to friend of the court, and when I got this on April 14th, and friend of the court had no knowledge, they had to actually look into it, and there should be some emails looking into it. They later determined if a full marriage did take place, they don't care who insures the kids on that end, but they did not call and get this approved ahead of time. I'm sorry that they did lie, though.
Well, we may have to hear from friend of the court. Right now, I'm sorry, go ahead.
Their exact wording was, I've entered the insurance information in our system that children have coverage through a third party, Christy Worrell. That's directly from Amy Wright from the court.
So we did call private.
What was the date of that?
That email was on that's the most current one. I apologize. Let's see. This one is on October 9th for again. And then, because we changed the insurance again, the first one was when I sent the email cards to Liz was on May 5th.
That was after the 14th.
That was much after.
Prior to us changing over, we did call, because I was with John, and we did call the friend of the court because we were not going to change the kids over to my insurance policy if they did not give us approval. So because I also have kids with other gentlemen, and so I know how the court system works, Judge. And so I was not going to allow John to let me put them on the policy if the friend of the court was not, if it wasn't under his his order, because I know what trouble it brings. And so I wouldn't put myself in that situation in doing so.
But we're literally getting sued because we insured my kids, which is court ordered.
And honestly, I don't know why they paid so much money, because from, if I can remember correctly, the policy was either $150 for the ER visit, and that was the deductible, and or it was $250. I can't remember which one. If it was admitting, it would have been $500. And so the policy I actually obtained was the highest PPO policy that I could actually obtain through my insurance company, so they could have the lowest out-of-pocket deductibles. And because I knew that Johnny was sick. And so, but me being a mom, I have 2 children, we have court orders as well. I would not have allowed John to let me put them on my policy without permission from front of the court.
And I feel that if she was as difficult with us in regards to just sending her insurance cards as she was with the hospital, I would, or with any of the insurance companies, I would assume.
Objection.
Okay.
I'm not sure. I didn't even hear what he said. But what he did say is, I'm being sued because I put my kids on my insurance as I was ordered to do by the court. Now, that is well and good, but her contention is because of that, I now have a $3,597 bill. But it doesn't yet sound like it's completely rectified. There may be a
actually send me the paperwork, Judge. I will fill it out and I can contact the hospital and submit that, because I also handle claims under my current position. So if she would like help with that, you could actually email that to us. I'll fill out the form myself and make sure that was covered under that insurance policy. And even if it was $250, John actually has something under the friend of the court to where she submits that into the friend of the court for him to pay through his child support. So, I mean, that's honestly, I would be willing to help fill out all those forms to make sure that all of that was covered if she was unwilling to use my insurance card because she is prideful.
Your Honor, they're twisting this around from really what's been going on in this
All right, well,
situation.
let me stop for just a minute. What insurance is on the kids right now?
I'm currently covering them under Blue Cross Blue Shield as a primary, which is why her primary is not impacting the children right now, because they're under me and they have Medicaid as a secondary. Medicaid works with any primary as long as there's no dependency issue. They were notified that there was a dependency issue prior to the children receiving any bills, and Christy Worrell and John could have at that point in time dropped the insurance. There wouldn't have been any issues. There wouldn't have been any bills. They refused to.
The problem is he's ordered by the court to have insurance on the children.
And there was no problem with him covering the children.
Okay.
And he also had lapses in insurance prior. What had happened is, once they used the children's information, and I had found out that they had used the information and it wasn't going to insure the children and it was going to mess up our son's healthcare. And I had a whole bunch of prior authorizations and things for him to be sedated for like his MRIs and all these things set up. And it's still now delayed to this day. And it's a big thing for our son to have care delayed. So they can paint a picture that they're trying to help. But what it was is there's a huge other problems going on with financial control and abuse. And this would put me in a worse situation. There's
All right,
a whole
well,
other
let
case
me
going
back
on.
up. He's ordered by the friend of the court to provide insurance for the children. That
Yes.
order's in effect.
Yes.
So he provides coverage for the children through his spouse's health care.
They filed this, I believe, with the intention of insurance fraud. They state this back to 1/8 of 2025, but they were at my house on the property with police called on 1/25 of 25, and they did not report themselves as married to that officer. They presented themselves as boyfriend and girlfriend. What they did is they filed an informal marriage after I reached out to the state of Texas and said someone had used my children's information without legal grounds to use the information to start this policy that's now impacting my children's health care.
So I don't believe that. I don't think he went out of his way to insure these kids just to screw with you. I think he was trying to comply with the court's order. Now, so you're rejecting that coverage for the children currently?
They had ended it. They basically screwed it all up. And then she cut the policy. Why did you cut the policy? You can ask her. I don't know.
So you called my job so many times, they fired me. So thank you.
I never called the employer. I called the beneficiary
All
line
right,
through Aetna.
so,
They fired
so you
me
lost,
because how many
you
times-
lost the job that had that insurance?
Yes,
Is that
sir.
true?
She called so many no, that's not my current position. I'm with a different company, but she called my job so many times, they let me go the following week. That's why they lost coverage at the end of June. So thank you for that.
I never did had anything to do with
I know it
her
wasn't
or-
your intent. However, it happened.
All right.
They also just recently sold.
All right, stop just for a minute.
Yes.
All right, so you put them on this coverage either in April or May. Then because she called your place of employment so much, they fired you. So
Yes,
you
sir.
lost your job and lost that insurance.
Yes, sir.
All right. So are the kids on any insurance between the two of you now?
Yes, so I actually, I waited because I waited till I found a good company because healthcare is kind of hostile. And so I found a company that I'm currently working for. And that's why I get it confused. Some start within 30 days, some start within 60 days, some start within 90 days. So it's hard to keep up with. But with my current employer, it started as of 10/1 of 2025. And it's also an Aetna policy. And the max out of pocket for both policies, Judge, was no more than $4,000. So one visit to the medical, you could have gone to the ER. That bill alone, if she did not file under insurance and paid the $250 deductible and sent the bill to John, it would have actually covered everything moving forward for Johnny at zero deductibility. Same thing with this policy, Judge. I got the highest PPO plan possible because I know he is ill and I have children myself and my daughter is also ill, also has a blood disorder. So it's very important that they have the policies correct. And so I made sure that they had the least out of pocket expense and the lowest deductible to make it the most easy. So Donna can just submit any receipt that she has into the front of the court, which it seems she's refusing to do so.
Not to mention that the deductible, from my understanding, gets eaten up by the state insurance that
Well,
she
it's not
has.
just the deductible, it's the max out of pocket. I got the lowest max out of pocket. The deductible for my current policy and now I think for family it was 4,000 and for out of pocket it was like maybe 4 or 6 for the last one. This one is only 6,000 and $1,000 deductible. So literally one visit to the doctor's office and it'll cover everything.
All right, so right now, these children are covered under your employer's Aetna policy from Texas.
Your Honor, I pay $1,600 a month for my children's insurance.
I didn't ask you anything. I'll come back to you in a minute. So are they on your policy in Texas
Yes, sir.
as of
The same way-
October 1?
Yes, sir. The same way I did it last time, I did it this time. They offer a domestic partner and then domestic partner dependent, and I can actually send that into the court so you can review it.
All right. Ms. Brown, your indication is that you now have a Blue Cross Blue Shield policy?
I've been paying insurance because I had to do what I had to do to make sure that our son could get his medical care needs met.
And when
I also would like-
did you start that?
In June. And I also would like to show Miss Worrell just sold her home. And she sold her home and signed a single affidavit at the same county in Texas. And here is her official deed that she sold her home. This was public records. I only obtained public records. I also never contacted her employer like she's saying multiple times. And she has just recently falsified a police report.
Stop.
But I'd like you to see.
Stop. That's not relevant. I believe she got fired because you called her boss in her
I'm
employment.
not called the employer.
Well, I believe she lost her job because of your earnest efforts
My
regarding this
understanding is she had
insurance.
misdemeanors unreported.
All right, now, so you bought your own policy here in Michigan in June. So are the kids double insured?
I'm not aware that they even have a policy. I just know that right now, when I've gone to the doctor, no other policies have showed up other than the Blue Cross Blue Shield, and the Medicaid is a secondary.
She should have received that from the front of the court. It said, again, we sent it to the front of the court on October 9th, where it says that showing the children have coverage to a third party, Christy Worrell.
Effective 10/1/25, medical and RX coverage, vision and dental coverage as well. I got, like I said, Judge,
Because no matter what Miss Brown does, you're still ordered by the friend of the court to provide health insurance. Is that correct?
I am.
I offered with friend of the court to sign off on that coverage just so that they wouldn't mess up, so that my son can't get his health care again and me get stuck with $3,000-$4,000 in bills. If they cover an insurance, it has to actually cover the children and not kick him out of all of his other insurance. The problem is I'm out financial losses from this decision, and they chose to not remedy it. All they had to do was.
I can get the form to fill out for you, because I know that you didn't turn in the insurance card and now you brought us here and it's frivolous. But if you would actually send that to the friend of the court to send to us, I'll fill it out for you. I'll call the hospital and I'll get it taken care of for you. And I'll submit all the receipts to the friend of the court.
Your Honor, there's been some extreme manipulation into the children's health care, because John is wanting the kids to go to Texas, and there's flight restriction list. They have both called University of Michigan MOTS, and they have prevented health care for the children. They have made it where my phone number has been changed. And what has happened is it's extending out my son to get his MRIs and his images, which will make him ineligible to go to Texas for the visitations. And that's what this is probably over. There is more to this story. They might sit there and tell you that, they're nice people trying to insure the children, but you weren't in the PPO hearing this morning. I'm out thousands of dollars. We have him and I still.
Well, you're not out yet. Sturgis Hospital's out at this point. If some insurance company will pay it, it could be reimbursed to the hospital.
I just want to be rectified for the amount that I'm out of pocket had this not happened.
Yes, and let's assume everything that you say is correct. Then what is it? Is it an unfortunate accident? They have a court order to provide insurance.
John does. Christy does not.
Yes. He loses his job. His wife, or whatever they call it in Texas, domestic partner, agrees, which she didn't have to put the children on her policy. They say they called the friend of the court and told them that, and they did it. Then in the case of the right hand, not knowing what the left hand was doing, it somehow made your children ineligible. And I'm still not completely clear about that. But
Your Honor, he quit that job.
Stop. I'll give you a chance to speak. You didn't have a chance to coordinate my thoughts. So what is that? He follows a court order and gets insurance. He checks in with a friend of the court and they say, okay. Unintended consequence is that there's an unpaid bill. They maintain if it was submitted, they would submit it and get it paid. Your theory is that they somehow did this with nefarious intent. So what's your response to that?
Your Honor, I've been subject to extreme financial control. Mr. Redding and I, we own a home together. I had, during this same exact window, I had a forbearance for the home that was filed, and he called and canceled that so that I would almost lose the house into foreclosure. The house was run through court. He ended up requesting dismissal based on rights of survivorship so that I couldn't sell the house. So I've been completely financially trapped in this situation. All of those other things were added on, all of his sales. That's his job that he's not reporting to the IRS or to the friend of the court, making hundreds of thousands of dollars a year. Him and Miss Worrell have just recently bought a new home. On the old home, she filed single and not homestead when in the same county in Texas. So that would hide the asset. He owes over almost $10,000 in back child support. Yes, he quit the job, but he didn't quit the job to help these children and put them on her insurance, like he's saying. There's a whole lot of backstory to this, Your Honor, and I'm being honest. A whole lot of backstory of domestic violence and everything else that's going on in Judge Patterson's courtroom right now, and with the home and with finances. And this was just one other tool. This was just one other tool to set me back. They were made aware. I told them, this is going to charge me out of pocket. Please remove the insurance so that the children can continue the care under the Medicaid. All they had to do was remove it. We could have worked with friend of the court or changed an order. They could have put in a request to not have to insure the children. That didn't happen. They knew that the children would not be covered due to this dependency issue. They continued to keep the insurance. It in turn caused me out thousands of dollars. It increased more financial strain to me. There is a lot more. Then a false police report was made, and even to you in this court saying I harassed an employer. She did not, she lost her job over what I'm assuming is at a healthcare facility and didn't report her misdemeanor. She is also being charged right now for child endangerment or neglect or hurting her.
Pending, and that is irrelevant.
Stop. Is there any more bad stuff you want to say about them? This isn't about that. This is about all the background. And you're angry and you're resentful and you've got a list of grievances longer than my arm.
Yes.
But they followed the friend of the court order to provide insurance. You didn't have the authority to unilaterally tell them to take the insurance off of there. This is also more a front of the court matter than it is a small claims matter. And people often try to jumpstart a divorce or custody and visitation order by taking it to small claims court. So that's the first fundamental problem. It's a front of the court issue rather than ours. And secondly, I find they were in compliance with the court order. So I find for the defendants, the damages are zero. If you want further argument in the front of the court.
Your Honor, I can't submit to front of the court beyond the time that it took for the insurance to try to run these bills. That's why I'm asking you to please help me make this right, that they have.
Well, you can give the bill to them and they will do it. But I find that they were complying with the front of the court order and they provided the insurance. You take her out, she get a copy of that. We'll send a copy to you. All right.
The 10th.
Okay.
My calendar has been given to the clerk's office, or you will get it. So
I've got it pulled in, so I had it entered right. We could do
it changes daily, so just make sure you get the most current iteration of that. So
could do March 11th for trial. It should be just a one day.
All right. Go ahead and show it set for March the 11th, and then if you settle all of these cases, you can set it for. You can do it on February the 10th if you want. Thank you, Judge. Thank you. Now back to the jail.
Your Honor, this is Mario Cassio, page 1, docket number 19748.
All right. Mario Trinidad Cassio.
I represent Mr. Cassio, Judge. This is a status review on the mental health evaluation. That was filed at the beginning of November, I believe on the 3rd. Dr. Moore, I don't believe, to my knowledge, has seen him yet, or at least I haven't gotten a report from her yet.
All right. So you want to reset this for the March 10th date as well?
Can we, Judge?
Mr. Cassio, we're waiting on the results of your evaluation so that your lawyer has all of the information necessary to help you with your case. So we're going to go ahead and reset it for March 10th. Give him a chance to talk with you and see what you can work out. All right.
Your Honor, can I say something?
Yes, sir.
I've already had my evaluation. The only thing I'm waiting for is for me to get paperwork to give to sign so they can get my medical records. I was supposed to sign it that day, and it's been 3 weeks, and the sheriff's office has not given me the paperwork. And that's all she's waiting on is for me to sign paperwork for my medical records to be released to her.
All right, well, what we're going to do is let Mr. Vaughn, who's your attorney, can check into that and find out why the results have not yet been provided to us. But as soon as he has those results in hand, he'll talk to you about what your options are, and you and he can decide what's in your best interest, and then we'll move forward from there. But I want you to understand that he's working on your behalf, and he needs to have that evaluation, okay? All right, thank you. Anybody else who is counsel here will all stand up at once. I will take you up on arraignments and short matters in between the jail cases. So what is your name? I'm sorry, what is your client's name?
Julie Riggs on behalf of Jason Mangum on page 5, Your Honor. We're not Mangum, M-A-N-G-U-M. He's present in the back of the courtroom, Judge, and we're not quite ready to set this for trial. We'd ask for one of those March dates.
So you have any opposition?
No, Your Honor, I think she was just recently retained.
All right, so you want to set this for March the 10th as a final plea day? March the 10th. That will be the last day that we'll be able to accept a settlement, so make sure that you get everything done before then. Okay?
Yes, Your Honor.
We'll sign a trial date if it's not resolved that day.
Thank you. May I be excused?
Yes.
Thank you so much.
All right, at the jail, who do we have?
Your Honor, this is Christopher Finch, page 2, docket number 18990.
All right, this is Mr. Finch. You're here to be arraigned on a charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, I need a lawyer.
All right, I'm going to report the public defender's office, and Mr. Winston Bond, who's one of the assistant public defenders, is here. So we will appoint their office to represent you. Do you wish a formal reading of that affidavit?
No, Judge, we'll waive that in our plea night.
All right. Plea of not guilty is entered. Do you want to set this for the 18th?
Whoops. Doesn't appear that there's any kind of pending charges. Yes, Judge. Let's see.
All right, we're going to set you for November the 18th to see if we can resolve your case.
Yes, sir.
All right, we'll be up to talk with you. Thank you.
Knowles, Kelly Knowles.
Mr. Vandervoort, you said you had something? Hunt?
Yes, sir. And Judge, we would like to reset that to March 10th. There's still discovery that's ongoing in that matter.
All right, March the 10th. I assume the state's in agreement with that.
Yes, ma'am.
Due to discovery, we'll reset it for March 10th. If it's not resolved on that day, we'll assign a trial date.
Thank you, Your Honor.
Thank you. All right, at the jail, who do we have?
Your Honor, this is Shelley Knowles, page 4, docket number 19786.
Ms. Knowles, you are here to be arraigned on a charge of aggravated assault and domestic assault. You have the right to an attorney. Do you wish to have a lawyer represent you?
I thought I did have an attorney.
All right, well, you may have.
Your Honor, the public defenders had a conflict, and I was appointed in general sessions, did the preliminary hearing, so if the court wants to appoint me.
We will appoint Mr. Jake Lockhart on the Cheatham County Bar to represent you on this. I'll hand him a copy of the indictment. You wish a formal reading of that?
Your Honor, waive a formal reading, enter a plea of not guilty.
Plea of not guilty is entered. General, when do you want to set this?
That's a Miss Sylvie case, so she tracks with me, I guess, for plea in March as well.
All right, March the 10th. For status, the lawyer will be up to talk with you. See if we can get you ready for a disposition or a trial.
For the clerks, that'll be General Sylvie.
Shelby Sylvie.
Yes, sir.
I'll get down to see you again.
Mr. Lock, the other Mr. Lockhart, so.
Page 1, first case on the docket, Ryan Babcock.
We need to do like there was with Jennifer and good Jennifer and bad Jennifer and like you, and we have good Lockhart and bad Lockhart here.
I'll let you make that judge as to which one I want to be. I hope I'm the good.
I think I know the answer already, but we'll go from there.
Judge, Mr. Babcock here in first row. We're simply going to place that on the 18th with the general's approval. We're trying to get in touch with the victim. And,
March 18th. Is that,
December.
I'm sorry,
December 18th.
No.
November 18th?
November.
November 18th, all right.
This month's a
Next week. All right, thank you.
All right, thank you.
All right, I'm sorry, at the jail.
Your Honor, this is Roy Mayo, page 5, docket number 19423 and 19424.
Good morning. I represent Mr. Mayo. And Judge, today we're asking for one more date. I know that we had previously set this to set for trial. We've got an expert in this case. I've passed on the information my expert's asking for from the state. I believe we'll get that wrapped up pretty quickly. So as soon as Your Honor, whatever available date you have next, whether it be in February or March is fine with me.
Well, in February, I'll be in Waverly, Tennessee, or in Humphreys County. So I'm back here in March. And it just becomes a question of, do we want to go ahead and assign a trial date, General, or do you want to?
Not at this point, because like he said, I need to give him access to his expert for whatever evidence we have. I'm not sure we have much, but.
And we will set this for March the 10th, but that will be the final plea day. So we need to get everything resolved so that you can resolve it on that day or set it for trial.
Yes, Your Honor. And Mr. Mayo, I'll come see you soon. Thank you, Judge.
Thank you.
Good morning, Your Honor.
Good morning.
Have Paul Harris, 2024 CR 19646. Your Honor, we've reached an agreement with the state to propose to the court in this matter. This is an 11-count indictment. In count 10, he would plead guilty to the amended charge of harassment, a Class A misdemeanor. He'd be sentenced to 11 months, 29 days. That would be suspended to unsupervised state probation. He would have no contact with Olivia Young, Shavonna Shaw, and William Shaw. No contact includes direct and indirect contact, as well as posting on social media. Counts 1 through 9 and count 11 would be dismissed in settlement.
All right, Mr. Harris, raise your right hand. Let's have you placed on the road.
I do.
State your full name for the record. You can put your hand down now.
I'm sorry, I can't
You
hear
can put your hand down, but state your full name for the record.
Paul Harris, Paul Drake Harris.
Stand right there in front of that microphone. Move over to your right a little bit. All right. This is a hard place to hear in, so.
It is, and I'm hard of hearing, and.
You're not the only one in this courtroom who's hard of hearing, so just know that. State your full name again, please.
Paul Harris.
All right, Mr. Harris, you are here today charged with a multi-count indictment of harassment. It's been indicated that you're going to enter a plea of, is it a guilty plea? Is that correct?
Correct, Your Honor.
You're going to plead guilty to 1 count of harassment.
Yes, sir.
But do you understand what you're charged with? Have you seen or been shown a copy of those charges and talked them over with Mr. Clark, and you and he discussed the range of punishment you're facing as well as any possible defenses you might have?
I do.
Well, it's indicated that you want to enter a plea of guilty. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury?
I understand.
Do you understand that you would have the right to have a lawyer, and if you could not afford your own, you would be able to have one appointed for you if
Yes,
you
sir.
found you indigent?
Yes, Your Honor.
You don't have to hold on to that microphone if you don't want to. You don't have to hold the microphone. There you go. Do you understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, Your Honor.
Do you understand? Do you want to give him that opportunity? All right. Maybe this will assist you. Do you understand that if you went to trial, you and Mr. Clark could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena?
I do. Yes, Your Honor.
Do you understand that you would be presumed to be innocent at trial? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify in your own trial?
I do. Yes, Your
Do
Honor.
you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving your right to a trial and to an appeal? And all I'm going to do is approve what you and Mr. Clark have worked out with the state.
Yes, Your Honor.
Do you understand that's going to result in a conviction, a misdemeanor conviction, but a conviction nonetheless, that will be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime?
I do. Yes, Your Honor.
And do you understand that this means, according to this agreement, the state, for whatever reason, they have agreed with your lawyer that that your sentence will be suspended to unsupervised probation? which means you're going to have an 11-month and 29-day jail sentence hanging over your head for the next 11 months and 29 days.
Yes, sir.
And even though you're not reported to a probation officer, if you violate the law, if you violate this contact order, this no contact order, then you will go to jail for 1 year. Do you understand that?
Yes, Your Honor.
You understand everything I've explained to you?
I do.
Do you want to plead guilty according to this agreement and waive your right to a trial?
Yes, Your Honor.
Was your decision to plead guilty today voluntary?
Yes, Your Honor.
Anybody forcing you to do this against your will?
Yes, Your Honor.
Is anyone forcing you to do this against your will?
Oh, no, Your Honor.
Do you understand I can't accept your plea unless I'm satisfied that you are guilty and there are facts to support it?
Yes, Your Honor.
Then I want you to tell me, are you in fact guilty of this charge as charged?
I am guilty.
And is the state going to give me the factual basis for it, or it speaks for itself? It's a harassment, correct?
It would waive factual readings.
Right. They're waiving a factual, but you understand that you have been charged with the harassment of Olivia Young, Shavonna Shaw, or William Shaw, and you're to have no contact with those individuals.
I do. Yes, Your Honor.
And that means direct or indirect, as well as electronic contact and social media posts referencing the alleged victim in this case. You understand all of that?
Yes, Your Honor.
All right. Then I would ask you then, are you guilty of this harassment charge as you have indicated?
Yes, Your Honor.
Are you satisfied with your attorney's services?
Yes.
You feel like Mr. Clark has done a good job of representing you?
He's done a wonderful job. Yes, Your Honor.
Clark, do you know of any reason he should not enter this plea? Anything further from the state?
No, Your Honor.
Then Paul Drake Harris and docket number 2024 CR 19646, upon your plea of guilty, I find you guilty of one count of harassment, and I sentence you to 11 months and 29 days in the county jail that will be suspended on 12 days that you previously served. We'll give you credit for those days, and it will be suspended to unsupervised probation. Your probation is conditioned upon you having no contact with Olivia Young, Shavonna Shaw, or William Shaw. That no contact, as I previously stated, means that direct or indirect contact, as well as electronic contact and social media posts referencing the alleged victim. The remaining counts are dismissed as a part of the agreement. You need to see the clerk. I assume he's paying the court costs. Is that correct?
Yes, Your Honor.
You'll need to see the clerk about the costs. Thank you. All right, at the jail, if you'll unmute, please.
Your Honor, this is Christopher Oliver, page 6, docket number 19618.
All right. Mr. Oliver, you're here to be arraigned on a charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
All right, we'll appoint the public defender, and they're represented here by Mr. Winston Vaughn. And Mr. Vaughn, do you wish a formal reading of that?
No, Judge, we'll waive that in a plea not guilty.
The plea of not guilty is entered. When do you want to set this?
Can we do?
We'll put it on November the 18th, and if it needs to be put off, we can put it off. We're going to set you for next week on November the 18th for hearing if it can be heard on that day. If there's some reason it needs to be postponed, we'll give you another date.
Thank you, sir.
Your Honor, I have Messiah Israel on page 4 of the docket. Mr. Israel's here in the courtroom in the back. We're here to get a date.
All right, so you need a date.
Yes, Your Honor.
And this is a stalking charge, is that right?
It is. There's 2 of them. 2 charges.
Violation of the order of protection and restraining order and stalking. All right. You want it tried this month?
Sure. I don't think Miss Sylvie would be appreciative of that, or General Sylvie, but.
So if you're going to set it, you're going to have to set it in March, is that correct?
Yes, Your Honor.
I'm standing in for General Sylvie today, and from her notes, she has March 24th and 25th specified with her Cheatham County Court.
March 20, let's just do March 25th.
25th.
Right.
Thank you, Your Honor.
And this is Israel, is that correct?
It is, Your Honor. Thank you, Your Honor.
All right. All right, at the jail, if you'll unmute, please.
Your Honor, this is Kelly Reed, page 7 and 8, docket number 19426.
Good. Public defender, you represent Mr. Reed.
Yes, this is Mr. Richter's case. Is it a amended VOP or?
This is an arraignment on an unlawful exposure. No, I'm sorry, that's a different case. This is Kelly Reed, so it's a probation violation, and it's an amended violation of probation arraignment.
Okay. Yeah, we put this on the December docket for wait formal reading or plea not guilty.
Plea not guilty is entered. When do you want to set this one?
December, please. December.
December.
Is there a VOP date then?
16th is what I have.
Got
For the 16th of December is what I have.
December 16th. All right. Your case is set for December 16th to allow Mr. Vaughn to have an opportunity to get ready for your hearing. Thank you.
Good morning, Your Honor. Just on behalf of my client's name is Richard Birdwell. I represent the Dismiss House, which is a treatment and reentry program. I was just informed this morning that he moved out a couple of weeks ago. I tried to get in contact with him and have not heard from him. So we will be withdrawing that motion to waive costs.
So on Richard Birdwell, the reason it's here was an appeal from the ruling in general sessions, and it was to appeal the cost. Is that right?
Yes, Your Honor, that's
and you're
correct.
striking your notice of appeal then.
That's correct, Your Honor.
The appeal is dismissed on your motion. Thank you. All right, at the jail.
Your Honor, this is Joshua Widener, page 8, docket number 18322.
All right, Mr. Widener, you're here to be arraigned on a charge of violation of community corrections. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
We'll appoint the public defender who's here in the courtroom, Mr. Winston Vaughn. Mr. Vaughn,
Wait formal reading or plea not guilty, Judge.
plea of not guilty is entered, and when do you want to set it?
You can probably do this one next week, that it looks like.
All right, we're going to set you for hearing on November the 18th. If Mr. Vaughn needs more time, then we'll give you another date. But right now, you're set for November the 18th.
Okay, thank you, Your Honor.
Thank you.
Morning, Judge.
I'm taking up whoever walks up to the podium. So.
I have a plea for you, Judge, Mr. Chauncey Spence, and he is in the courtroom. I'm not.
What was the name?
Spence Spence. Sorry, Judge, I don't know the docket number. I'm sorry, the page number.
8. All right, I've been handed a document indicating that Mr. Spence is going to be entering a plea of no contest to count 3, possession with intent to sell a Schedule II drug, Class B felony, and he would receive a sentence of 8 years in the Tennessee Department of Corrections, suspended to supervised probation. He would be ordered to pay court costs and the mandatory fine, which is $2,500. Is that correct?
I was unsure, Judge. I didn't know if it was 2,000 or 3,000. And I'm trying to get clarification on that.
Mr. Willoughby is back there.
Put your hands, everybody.
Do you know what what is the minimum?
It's 2,000.
How much?
I said, I think it's 2,000.
2,000. All right.
Thank you, Judge.
We'll put that in there. The remaining counts will be dismissed. So Mr. Spence, raise your right hand. Let's place you under oath.
Yes.
Thank you. You can put your hand down. Now state your full name for the record.
Chauncey Spence.
Mr. Spence, you're here today on an indictment charging with a sale of possession with intent to sell of a controlled substance, and there was a multi-count indictment. It's been indicated you're going to enter a plea of no contest to 1 count, and the rest would be dismissed. But do you understand that no contest plea means that you are not saying you did anything wrong? You're not going to admit anything, but you're not going to contest the state's evidence, and then they're going to tell me what their evidence would be at trial, and that evidence will be used by me to find you guilty according to this agreement. Do you understand that?
Yes, Your Honor.
Have you seen or been shown a copy of those charges against you and talked it over with your lawyer, and you and Ms. Stevens have an opportunity to discuss the range of punishment you're facing as well as any possible defenses you might have? You
Yes.
feel like you understand what you're charged with? All right. Do you understand that you would have the right to plead not guilty and to have a speedy and public trial by jury in this court?
Yes, sir.
Do you understand that if you went to trial, you'd have the right to have a lawyer and to have one appointed if you could not afford your own?
Yes, sir.
Do you understand that if you went to trial, you and Ms. Stevens could confront, I'm sorry, if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of any crime?
Yes, sir.
Do you understand that if you went to trial, you and Ms. Stevens could confront and cross-examine all witnesses the state called to testify against you, and you could bring in your own witnesses by using a subpoena?
Yes, sir.
Do you understand that if you went to trial, you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify in your own trial.
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that if you plead guilty or no contest, rather, you're waiving your right to a trial and to an appeal, and all I will do is approve what your lawyers worked out?
Yes, sir.
But do you understand that's going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime?
Yes, sir.
You understand everything I've explained to you?
Yes.
Do you want to waive your right to a trial and to an appeal by entering a plea of no contest?
Yes, sir.
And is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this
No,
against
sir.
your will? You understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges.
Yes, sir.
And I want you to listen as Mr. Willoughby tells me what the state's evidence would be if this case went to trial.
Yes, sir.
Yes, Your Honor, 19746 on January 9th, 2025. Agent Kent with the Cheatham County Sheriff's Office was traveling on Highway 12 past a white Mercedes. Knowledge that Mr. Fitz did not have a valid driver's license. Conducted a traffic stop. During the traffic stop, there was an odor of marijuana coming from the vehicle. They did search the vehicle as well as Mr. Fitz's person. They found a large sum of money in his pockets. I believe it's around $1,400. And they explained to him that if they took him to jail and he had drugs on him in the jail, that would be a felony. At that point in time, he handed over what turned out to be 4.5 grams of what he claimed to be heroin.
I'm not asking that you agree with the state's evidence, but you understand that's what they would prove at trial.
Yes, sir.
You still wish to enter this plea according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel like Ms. Stevens has done a good job of representing you competently?
Yes.
Ms. Stevens, you know of any reason he should not enter this plea?
No, Judge.
Then Chauncey Spence in docket number 2025 CR 19746, upon your plea of no contest to count 3, the remaining counts are dismissed as a part of the agreement. I find you guilty, sentence you to 8 years in the Tennessee Department of Corrections. That will be suspended to 8 years of supervised state probation. You're ordered to pay a $2,000 fine and court costs. He'll need to see the probation department before he leaves. Step around.
And Your Honor, I have two arraignments. I'm standing in for Mr. Bernie McAvoy for Carolyn Lee Williams.
All right, what's the first one?
The last name was Williams, Judge. Caroline. Oh, there's,
Caroline Lee Williams in docket number 2025 CR 19781 show that Ms. Stevens is the attorney of record.
oh, no, Your Honor, Bernie McAvoy. I'm standing in
Sorry,
for, yes, Judge.
The boy is the attorney of record.
We got that 210.
What day?
210, Your Honor.
210.
Thank you, Judge.
Bernard McAvoy.
And I have one more for Miss.
Copy of Ms. Stevens.
Thank you, Judge. One more for Miss Margaret Brady, Maurice Wilson.
Yes, February 10th. Maurice Wilson.
Yes, Your Honor.
No, because she's doing. So we just please. Pre-trial.
On page 9.
Thank you, Judge.
We'll show that Ms. Margaret Brady is the attorney of record for Mr. Wilson. And whether we want to set this one, General? Maurice Wilson.
Hey, John.
You just set it for 310 for plea.
210?
Yes.
All right.
Mark.
March 10th, okay.
And that will be, I will be the idiot.
All right, March 10th.
Thank you, Your Honor.
Can I call a name out, Your Honor?
Yes.
Courtney Williams. Courtney Williams is on page, the end of page 8, beginning of page 9. Can she come up to the podium?
Courtney Danielle Williams. States motion to modify restitution.
All that we're asking to do is have her put on a